May I, my lord, can you mention a very urgent matter, my lord?
Court number 19 or this court?
Group 1, my lord.
Group 1 matter, yes.
My lord. My lord, government is trying to forcibly take over land, my lord, any day now, my lord.
Upon notice?
Upon notice, I'm mentioning, my lord. It appear tomorrow, my lord.
I got mentally.
But it will appear on
Let it be aware.
Let it
It will be instructed by
this. Any day will take over. Tomorrow, it will appear.
Upon notice?
upon note. Appear.
Only group
Well,
1
it-
matters
it-
first,
it
please.
is
I'll
in
pick
the
up
mentioned
group
matter.
19's matters
I am-
later.
No.
Since
Nah,
we
right.
started with court 1, court 10's matter, please, group 1 matter?
Same thing.
What, same thing?
Group one, not,
Yes.
but urgency is not I could not enter into my premises. Not
Upon
affecting
notice?
of the high. Yes.
Upon notice?
I am paying urgency. Upon notice order covering an order, my lord, where part of the land has already been directed to be released and part of the land belonging to me. No order has been passed.
Upon notice?
Upon notice.
Also, may I permit to mention in the compelling circumstances, 3rd January, lawsuit, I mentioned this matter. After no service of notice, lawsuit was allowed this matter. Thereafter, matter was not listed. Also, 8th January, the monthly list was published. The matter was not in the monthly list.
Is it a hearing matter?
No. Motion matter. I asked lawsuits officer. Officer saying that in the mentioning slip, put the item number in the monthly list of the December, so the matter cannot be listed. 3rd January monthly list of January was not published. At the point of the December monthly list was prevailing. So I put.
Why don't you give a fresh mentioning slip, sir? It will be included. Yes.
Upon notice, I am mentioning, my lord, one matter, my lord, but another question, my lord.
Upon notice, give the number.
My lord, upon notice, my lord.
Group 1 was a new content matter.
New content, give the number, please.
My lord, upon notice,
Give the, yes, it will appear.
my lord, upon
Group 1 new contempt. Appear করছে না কেন?
my lord, upon notice,
দেখে নিন, দিয়ে দিন, কালকে দিয়ে দিন।
my lord, upon notice, I am mentioning this matter, my lord. For but I am not.
Give the number, please.
It lordship leave, my lord.
Group 1 matter, any
My
other?
lord, group 1 matter. My lord, group 1 matter. I am coming here challenging the 10-4 proceedings. Your lordships granted me protection for interim order on 28/8/2023. Thereafter, my lord, a public interest litigation is pending before the Honorable Chief Justice bench. And knowing your lordship, 15/9/28/8, your lordships granted interim order, and 15/9, your lordships not inclined to granted the interim order, not extended.
Yes.
And knowing this, the division bench proceeded. Challenging that order, I go before the apex court. The apex court granted me the liberty to file a modification application and obtain order from your lordships within 31st.
Are you mentioning upon notice?
Yes, my lord. Everybody has notice. Very urgent matter. So by 31st, my lord.
Show me the order of the Supreme Court.
For the last 2 pages, the operating part.
Let me see, please wait.
Facts are recorded. Thereafter, hold that I am remediless. That's why granted me liberty to file a modification application for extension on your, and your lordship's 2 orders are also annexed. Otherwise, I am thrown out, my lord.
necessary.
You have been directed to move the application within 31st January.
Well, otherwise,
So have you filed the
well,
application?
31st, up to 31st, I am protected.
Have you
Thereafter,
filed the application?
yes, this is the application I have filed more 4 or 5 days before. I filed it. This is the application. My lord, your lordship's order also annexed here. 2 orders. My lord, any date, my lord, except 22nd. Except
22nd.
22nd, my lord, any date.
My lord, with your lordship, my lord, one thing. My lord, one petitioner, my lord, your lordship had one day order. Order has been passed, my lord. Now, subsequently, the petitioner died. For substitution, I filed the application that is to be listed.
Upon the notice?
I noticed the other party said that he is no more in this case. They have left the case. He will not. It's only the restitution application.
Yes,
That was substitution application.
yes, but it should be mentioned upon notice.
Notice I have given, my lord, it is long back, my lord, 2020 case. He is out of panel.
Are you mentioning upon notice?
Yes, I have given him notice. I have met him personally.
Out of panel, you have to make a fresh service.
He refused to take it.
If he is out of panel, he cannot receive. Isn't
Yes,
it?
yes.
So you have to make a fresh service at the GP's office.
Yes, we also accept him.
The number, please.
My lord, I mentioned, my lord, the upgradation of the list, my lord. Upgradation, my lord. It is a compensation. Rail has been taken the land, my lord, compensation.
Upon notice? Are you mentioning upon notice?
Mentioning not notice.
Please,
my matter
please
is
mention upon notice. Please mention upon notice. Please wait. Number 19, I'll take up. I'll take.
Your lordship, may I
one
permit to
over?
mention
Yes, madam.
My lord, praying to for your lordship to mention one writ petition, my lord, pertaining to the West Bengal Public Land Act, Unauthorized Occupants Act, my lord. My lord, now the illegal encroachers are actually blocking, throwing rubble.
Mentioning upon notice?
Yes, my
Give
lord.
the number.
Your lordship, may I
Grateful,
permit
my
to
lord.
mention one motion matter, group 1 motion matter I mentioned, and subject to the other side, your lordship.
What is your urgency?
RGC petitioners of the recorded owners of the land, petitioners made a representation before the LA officer, but for disbursement of the compensation.
Give the number. Give the number. One over?
No,
My lord, may I be permitted to
One.
mention?
no, my lord, group.
Matter relating to fake stamp paper.
Fake stamp paper. Upon notice? Yes. Give the number.
My lord, may I be permitted to mention one matter of code number 19?
Yes, I'll take up quote number 19. Group 1 is over. I'll take up quote number 19 matters. Yes.
Extension of interim order.
Give the number.
Extension.
Upon notice.
Yes, my lord. I have notice. Yes, my lord. Notice, my lord.
This code number.
Oh, yeah, last week it was.
Yes. Group 1. Upon notice, give the number. Give the number.
My lord, may I be permitted to mention the matter was already mentioned, and your lordship was very kind to upgrade the matter. It is appearing, but it is coming down in the list. 22nd is the date fixed before the trial court. The trial court will proceed. My application will become infructuous. Your lordship,
যেটা কালকে একটু উপরের দিকে রেখে দিন।
immediate before 22nd, my lord.
কালকে একটু উপরের দিকে।
My lord, item number 721 of your lordship's days list. My lord, this is an innocuous pair, my lord, before your lordship for my lord, expeditious disposal of an application for visitation of the female child aged about 6 years. So, my lord, if it is not taken up, my lord, before the next,
Upon notice.
my lord, no caveat is there, my lord. My lord, let it be upgraded, my lord. Item number 721 be.
Please let me see. Give
My
the
lord, I shall.
Application. My lord, 7 I'm the defendant. Didn't defend 7 display without giving any reason. Next date tomorrow is the date.
For?
I am the tenant.
7/3 tomorrow.
7 book.
Tomorrow is the date for?
Did not hear it? But 7 or 7 then 7/3. Then my defense won't go. This is a very urgent.
Give the number,
But
give the
tomorrow
number.
is the date for in the trial court.
দিদি এটা কালকে উপরের দিকে রাখুন।
Lordship, may I be permitted to mention?
Extension of interim order. In spite of the interim order, the executive engineer issued demolition notice, my lord.
Group 1 matter.
No, my lord. It's obtained against the order of the building tribunal, my lord. It was till 15th January.
Stay was still.
15th January.
You have informed the authorities?
Yes, my lord. I have served, notice of the mentioning. Kindly,
Let it appear, let me see.
Lordship, may I
May I be mentioned
Give it a
to
name.
mention that court number 19 will not matter.
Yes,
Yesterday, because of the urgency, I wanted to mention the afternoon, I got the number yesterday, there is an extreme urgency because there is a status quo order passed by the DRT, which was affirmed by the single judge, also division bench.
But I appear for the
Suddenly-
respondents in this matter.
Suddenly, thereafter, DRT took up the application and packaged the interim order without giving the opportunity of hearing on the ground that the learned advocate without raised his voice. Because one supplementary affidavit relied on without serving the copy. But I am challenging that order. Now they are after that order, they are abruptly changing the nature and character of the property, destructing everything.
please serve the. he's
But I-
there.
My lord, may I be permitted to make one submission
Yes,
for your lordship, my lord? My lord, my learned friend made two points, my lord, for listing the matter urgency, my lord. Primarily, my lord, this revisional application has been filed in complete contravention to section 18 of the SUVRA Act. Let me submit. My lord, kindly consider,
Without jurisdiction.
let him complete.
my lord, there is a provision of pre-deposit under section 18 of the SUVRA Act. My lord, that is a mandatory compliance decided by the Honorable Apex Court, my lord, in Katina of judgment and recently in the case of Narayan Chandra Ghosh and Siddha Nilkant. Now, my lord, what they do is that order which has been impugned in the revisional application, that order, they have preferred a revisional application, they have preferred a recalling application before the DRT, which my learned friend does not submit before your lordship. My lord, he will not let me complete, my lord.
Let him complete.
I am not arguing on merit. Urgency, you have to show the urgency for mentioning. Now, my lord, they have preferred a recalling application. The DRT on contest adjudicated the matter, and the order and the matter is reserved for order. So, my lord, the DRT is the adjudicating authority, my lord. A court can pass a right order with deepest of respect and a wrong order. But, my lord, today, in order to maintain the revisional application, they have to demonstrate before your lordship where is the error in jurisdiction.
Yes.
My lord, they have preferred a revisional application before also. That got dismissed from court fee. My lord, they are doing nothing but forum shopping. And insofar as many words, my lord, in the present revisional application, there is no urgency at all because they have preferred a self-same recalling application of which the order has been reserved by DRT. So till such time, the
On
DRT
the same issue?
same issue, my lord. My lord, I have read the brief. I am appearing before the DRT in every order. My name is there, my lord. They have preferred an appeal. They lost the appeal. From the appeal, they have come up before this honorable court in a writ jurisdiction. Writ application also dismissed for want of court fee. And now, my lord, just in order to stall the proceeding before the Debt Recovery Tribunal, when the DRT has reserved the order in a recalling application from a self-same application, self-same order. My lord, they have preferred a writ application, my lord. My lord, insofar as many words, this writ is premature and not maintainable, and there is no urgency whatsoever. And they ought to wait till DRT returns a finding on the self-same order, of which they are preferring a revision.
In the meantime, no action is being taken.
Nothing, my lord, nothing. My lord, there was a status quo order which was vacated. My lord, pursuant to vacation of the interim order, they preferred a recalling application of that order. DRT on contest heard that order, heard that application.
But during pendency of the application, no step is being taken by the authority?
My lord, there is no authority as such, my lord. My lord, property.
They are demolishing the property.
My lord, there's no question of demolition, my lord, because an auction sale was held on which a property was transferred. The auction purchaser was put into possession of the property. Pursuant to putting the auction purchaser in possession of the property, they prefer an application before the DRT for sale, for stay. That application was heard, prima facie a stay was granted. Then we, as auction purchaser, participated before the Debt Recovery Tribunal. On contest, the DRT refused to pass an order.
So
On
that
contest.
order has been challenged before,
No, that order has not been challenged. What has been challenged is, my lord, they have challenged an order where the vacating order was passed by the DRT. Now, from that vacating order, a cost was imposed for 1 lakh on the learned advocate, for the learned advocate, on the basis of the fact, my lord, the learned advocate did not permit the DRT to proceed with the matter when the DRT was convinced with my submission. So, my lord, in order to, my learned friend is referring to a supplementary affidavit. My lord, I was there in the proceeding. My lord, the supplementary affidavit was not pressed by me. And it is also there in the order. Now, my lord, that order which they are impugning in this revisional application, from that order, they have preferred a recalling application. On 30th December 2023, that was heard, and matter is reserved for order. My lord, they have annexed the order in the revisional application. My lord, in spite of that, my lord, this writ application, there is no urgency till the DRT returns a finding.
But kindly see, so many things has been said. Kindly see this order of the Rani single judge, affirming the order of the status quo. Thereafter.
My lord, these orders have lost,
Both of
these
them are-
orders have lost the status.
This doesn't hold the field now.
Lot of safety says.
The Supreme Court has clearly recorded in the case of Satyavati Tandon, Naveen Philip Matthews.
This is without.
There's no urgency in the writ application, my lord.
Kindly permit me.
My lord, my learned friend is just doing forum shopping.
Please serve notice upon the opposite parties. It's served.
Already
My lord, yes, sir.
Not auction
Let
purchase.
it appear in the list. Let
Kindly
it appear in the list.
Yes, my lord.
Lordship, may I,
The number, please, it will appear in the list.
This is the number.
Let it appear.
Lords,
My lord, there's only one impediment, my lord. My lord, this will appear in the list tomorrow, my lord.
Let me see. Let me see.
Lordship, may I be permitted to,
There's a long list of court number 19 also, so let me see.
My lord, the
Let me-
for 2 days, my lord, I am little, my lord, for 2 days, 23rd and 22nd and 23rd, Monday and Tuesday, my lord, I'm a little dispossessed, my lord.
Before that.
Let me see. Let me see. Let it appear.
Lords,
Under that in navigated matter. My lord, what happened? My lord, the last date has been fixed on to my lord. My lord, the court below directed to this one. This is the absolutely, my lord, that's why.
24th of January.
My lord, I appeal for the respondents, my lord. There is no urgency, my lord. The order impugned, according to me, my lord, the civil revision is infructuous. Because, my lord, the order which is being challenged here, my lord, by subsequent order, that order has been vacated, my lord. That order is not under challenge. So practically, the civil revision is not maintainable. There is a subsequent order which says that the earlier order which is challenged before this honorable court is vacated.
That order,
So that's why
that order has been specifically mentioned that I have given a last chance.
The order that you're challenging has been vacated. That is-
Subsequently, order has been challenged.
that order is not being
How does
challenged.
How does your application lie now? In view of the change of circumstance?
The subsequent order is there.
So withdraw and file a fresh application.
That is before the reply. Hard out as a one, it will take.
Clear out a matter which has been vacated. This doesn't have much of time, sir.
I have no knowledge about the.
Please
I can place the order, my lord.
gather knowledge and come back to me. Please gather, no. Please gather knowledge. 25th, in any case, the regular bench will be back. No. No.
I can place the order, my lord, before the court. I can place it.
Please take note, gather knowledge of the order and then come back. Can't, if I can rely on your submission, why can't I rely on his submission?
I can place the order, my lord. I can place the order, my lord. I can give it to him
Before
also.
the regular bench.
Lordship, may I be permitted to mention one matter, Lordship? Lordship, on earlier date, Lordship was pleased to allow this mentioning, but one colleague of mine wrote the wrong case number. So wrong case is running in the list, Lordship. The correct case number is CO 17.
Please give the number.
Lordship, in the learned code,
Is correct now?
Lordship, but Lordship, in the learned code below, tomorrow is the next date, Lordship. Kindly.
Help, you have lost your chance. Can't help.
Yes,
Let
my
it
lord.
appear, let me see.
My lord, for application matter, short-term mining license, petitioner already fees paid, concern authority.
Upon notice?
Yes, my lord.
Give the number.
Your lordship, I'm mentioning for
710, my lord, upon notice, my lord, other side, my lord, is.
Group 1.
No, my lord, this is.
What is your urgency?
25th date has been fixed, my lord. The matter is, my lord, already there is the direction of the honorable high court, my lord, to dispose of the matter within 6 weeks, 6 months. That has not been done. That is the case. So, my lord, kindly.
No urgency. The bench will be back on 22nd. You can move. 22nd and 25th, there are 3 days in between.
your lordship.
Regular.
I'm mentioning for extension of interim order, your lordship.
Upon notice?
No, yes, court number 19 matter.
Yes. Extension of interim order.
No caveat has been filed.
Extension of interim order, the other side is on record.
Yeah, no, your lordship. In the motion stage, it was heard. Extension and interim order was passed. Thereupon, I was served. No, I've served the. No, they did not appear. The year after, it did not appear.
The number is- Group 1 here, mentioning is over.
I do not.
Hearing matter.
No, my lord, this is group 1 matter. Your lordship had on 21st of December, and your lordship please matter today, 17th of
Is it
December.
a hearing matter?
No, sir.
At the motion stage?
Your lordship directed my lord to take instruction, the state and.
It is not appearing today.
Appearing and under item number 3 on this one.
Yes, it's appearing as a motion. Correct. What is the mistake in it? Mentioned matters appear only on one day as mentioned matters. Then it goes back to the motions.
It was mentioned matter under the heading mentioned matter.
Yes, that is only for a day, sir. Then it goes back to the heading motion. There is no mistake in the order, nothing wrong. So it is appearing already in the list. So what is your problem? Yes.
My lord, may I be permitted to mention one matter? 25th is the date for execution. 25th of
20?
January.
25th January.
I am only praying for stay till the hearing of Section 5 application in with the appellate court. That is on 22nd February. I am only praying for stay.
You are aware that there cannot be any stay before Section 5.
No, Section 5 is allowed. If not allowed, then everything goes.
So there cannot be a stay before Section 5, sir. Foresee your Section 5 first.
No, that is in the before the appellate court.
Yes.
Execution court has fixed the date 25th of January. That's why I am.
Why didn't you make the same application before the appellate court?
Appellate court. No, appellate court. No, I cannot because Section 5 application until allowed. I cannot make the stay application.
So similarly, on similar grounds, you cannot. This court will also not grant stay, sir.
Execution court has rejected my application. That
I understand. You have not appeared before. You have not applied before the appellate court because your Section 5 is pending.
Yes.
So on the same ground, at least I will not grant you a stay. Let me make it very clear.
Maybe kindly.
Come appear before the regular bench.
Regular bench.
22nd.
22nd is there is uncertainty. Maybe a holiday.
Well, give the number. Give the number. Yes, call the days list, please.
Item 1.
Item 1, my lord, I understand that certain corrections are required to be made because this is an acquisition under
What
Act
is
2.
the correction required?
The correction, your lordship kindly see the order, right? The order copy with the order copy. Oh, what is actually to achieve? My lord, all right. My lord.
পেন্সিল গুলো শার্পেন করতে বলবেন তো একটা
in the first paragraph,
yes,
acquisition affairs, we ask. Prayer was that to acquire under 2013 Act. So, we will make a representation for in case they want to acquire, it shall be under 2013. And acquisition, your lordship.
What is the correction necessary?
Your lordship's circular number purchase in terms of 2016 circular, your lordship's kindly add. This is the circular number, mirror 20.
I cannot add anything in a correction application. You have to come for review in that case. I can only correct typographical
Only one thing,
mistakes.
your lordship. There are several respondents, which has two parts. One is acquisition part, other is
What is the correction, sir? I'm not hearing I'm not hearing
no,
the review
not hearing. I am saying kindly make it respondent number 3 and 4 only. The second page. Your lordship has directed us to kindly make it third respondent and fourth respondent because acquisition, payment of compensation is to be looked into by the collector.
Before the fourth respondent.
Fourth respondent is the executive engineer. He has nothing to pay compensation.
Demarcation or other things will be done by first month.
No.
That is for the respondent number 4.
Yes.
When payment of compensation, either purchase, that
He
will be
will
done by.
direct. After it is found, he will give necessary directions. It is absolutely no order need be passed. There is no correction necessary. No order need be passed. Next.
ঠিক আছে
Fourth
ঠিক আছে পারচেজে ঠিক আছে
Item 2. তাহলে কি হবে? Can 3 হবে এটা?
number 1 what number 1 that is apartment they are not mentioning that correction.
Item number 2. The can number is wrong. It will be can 3, not can 4.
What color?
In one is coming from the department, my lord, not for, we are not mentioning.
No, no, one is the petitioner mentioned, that is one.
Both of us is there, my lord.
But he mentioned for correction in one.
Mention.
Correction.
And we can put some mention to it.
He wanted to add 3 also, but that is not necessary.
No. Entire order.
No correction is required. Yes.
I know, my lord.
That is on upon mentioning.
He can, okay?
You can fully get it.
He can.
Inadvertent error has crept into the order passed on January 9, 2024. Paragraph in the said order, can 4 of 2024 be read as can 3 of 2024. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on January 9, 2024. Urgent certified website copy. Next.
Item 3.
My lord, I am for the respondent pollution.
Lord, 3 and 4, my lord. Lord, I am sorry, my lord, because otherwise, my lord, they have taken the brief from me.
So, but this is for release, I think.
Release.
This
Release.
pertains to group 5 or something.
No,
This is-
group 1.
This is with regard to land.
But there was a submission that it is for release. I বলেছিল না?
My lord, I have mentioned
Mentioned for release.
No, I have mentioned.
Who mentioned this matter? You mentioned.
I'm petitioner.
Yes, you asked for release of the matter.
Because, yes, my lord, there is having horrible life of the villagers. My lord, last 2 months, my lord, two persons, my lord, died with cancer or the environmental problem. And this is a matter of 19 and 20, it is fixed for hearing. Lordship also pleased to direct the matter will appear in the month of September 23.
No, you are asking for release of the matter.
Then, my lord, I have on basis of my mentioning, my lord, Lordship was pleased to direct, then try your luck to another court because it is not possible, my lord, for hearing of the matter. And it's a big matter.
Oh.
And I am specifically sorry, my lord, because otherwise they could have taken the no objection from me.
The petitioners for releasing the matter. Paragraph, the matter be released from this list.
Get to Lordship.
Next.
3 and 4, my lord.
Yes?
3 and 4.
3 is with 4.
Item 5.
My lord, it is appearing at my instance, my lord.
That I am for the respondent.
For extension of interim order.
No, my lord.
My lord,
My lord, we are ready. Matter is totally
better
ready and led by
already,
Mr.
my lord.
Mahato.
So, Mr.
You are the
Thakur,
petitioner.
No extension should be.
My lord.
My lord, let it be heard.
Let
Let it be heard, my lord. My lord, because of my lord, this is a.
My lord, the interim order. let
On
it
the
be-
earlier occasion, you did not appear at all, sir. Please do not raise your voice today.
Earlier occasion.
Recorded that none appears for the respondents and no accommodation was sought.
We have given a notice to the other side.
My lord,
My lord, let it be extended for a short period, Mr.
Absolutely.
My
Yes.
lord, Mr. Sen was leading me, Mr. Shah Sen, but we almost concluded any day as per your convenience of the honor.
This is a hearing matter.
Yes,
it is a hearing matter, my lord.
It's running in the list.
it was running in the list. Yes, ma'am.
It will again run in the list
My-
24th onwards. Because
Fine.
the 22nd, I'm not taking up hearing matter.
No, my lord, it appeared as item number 5 today.
It was running in the day. We had mentioned the matter and it has come as to be
It
mentioned.
was
for
in the list. It was on January 11 last.
It is at the motion stage, and there was
What
a
has happened, my lord?
there was a direction for report. Report was affirmed, but on that date I could not be, my lord, present. And my lord, the report. This is the report, and this is the case, my lord, that relating to the termination of the lease for non-compliance of the lease terms and condition of the lease.
My lord, we
It has
have-
been substantially heard, I
Yes,
think.
my lord. Mr. Sen
Yes.
Yes.
My lord, this is my exception to the report, so I can just
A
submit.
report
Yes,
submitted
yes.
on behalf, report in the form of affidavit submitted on behalf of the respondents and exception to the report submitted on behalf of the petitioner are taken on record. Paragraph heard learned. Paragraph, let the matter appear under the heading motion on
Top.
13th February.
So, my lord, at the top, my lord.
It will appear. Paragraph, the interim order granted earlier is extended till 29th February or until further orders, comma, whichever is served.
Well, at the top, my lord.
All matters are at the top. Yes, next one.
আপনার নাম লিখবেন
Item 6.
ওখানে কাগজ আছে
Yes, item 6. Go on. Inadvertent error has crept into the order passed on January 4, 2024. Paragraph in the said order, WPA 17359 of 2022 be read as 17359 of 2021. Paragraph 21 হবে. Paragraph, the department is directed to incorporate necessary correction accordingly. Paragraph, this order be treated as part of the order passed on January 4, 2024. Urgent certified website copy. Next.
7.
I am for the private respondent.
Lordship, I am appearing for the petitioner. Lordship, this matter relates to police in action, and this has been wrongly filed in this court.
No, my lord,
So-
police in action code has been delisted.
Yes.
Earlier occasion, my lord, kindly see.
Yes, Lordship, so I'm praying for releasing of the matter.
Is the matter due to lack of.
My lord, these matters is supposed to appear in code number 9. That is why it was released. Justice Sengupta released his, my lord, saying that go before code number 9. Before Justice Bhattacharya.
The matter relates to residuary determination.
But now,
The matter pertains to. The matter pertains to residuary determination. Paragraph, the matter be released due to lack of determination.
নামটা নাও এই দাদা একটু নাম দিও
Next.
নামটা এই নাম্বারটা নাম্বারটা
Yes, what is the correction?
Lordship, my lord had directed the 6th respondent to consider and dispose of the application by refer by me. Lordship, under 3G5, Lordship. The 6th respondent was the Special Land Acquisition Officer, Lordship. And Lordship, according to 3G5, as per statute, my lord, the arbitrator has to dispose.
Submission was made by the respondents. On their submission, the order was passed.
My lord, on that occasion, Lordship, there would have been assist your Lordship the name of the arbitrator. So, my lord, and we don't even know, Lordship, who is the statutory arbitrator. So that's why, Lordship, we have
So now, what is the what?
Only the thing is that, my lord, the Special Land Acquisition Officer could not take up the and dispose of the application under 3G5.
He cannot.
They may,
He cannot. He has no
yes,
authority.
my lord. Only he can forward it to the arbitrator. Only forwarded to the arbitrator.
My lord, that is
My lord,
that
the thing becomes after I present the application before the appropriate authority, Special Land Acquisition, he issued the notice for hearing, Lordship. He cannot took the hearing, Lordship, and he said,
please take necessary instructions, madam.
and he said that
He is not
in accordance with the Honorable High Court's order, I am proceeding. My lord's order became misconstrued.
on the land.
Nothing else is remain.
5 application. Who should be the authority then?
Arbitrator.
Arbitrator, but who is the arbitrator here?
My lord, at this moment, Lordship, I have to put assist your Lordship regarding the name, Lordship. I don't even know. Well, only Lordship, this,
Not the name, the arbitrator is,
only Lordship can refer this matter before the arbitrator, my lord.
Only the Lordship. That will suffice the entire situation, Lordship.
Preferred by my learned friend, Lordship, you can transfer this application in accordance with law before the who is the arbitrator.
It's a consent order. Because otherwise I cannot pass an order.
My lord, thing is that there are three similar applications. Files are there. However, it did not appear. I mentioned all the four matters and the same order passed by my lord.
Yes, on consent of the respondents.
My lord, only refer this matter. Lord, even today, Lord, I don't even know who is the arbitrator. My lord.
Yes, I'll pass a consent order because this is a correct. This has been mentioned for correction, and this is not a correction at all. This is a review. So by consent of the parties, let this direction be given.
Lordship, three more.
Yes.
My lord, three more.
Council's respondent is land acquisition, my lord.
Six.
Yes.
Special land acquisition.
The respondent is, my lord, is special land acquisition.
He has no authority.
Authority.
He should have forwarded. Instead, he has issued notice for arbitration. He could not have done that.
Forward this application.
Heard learned counsels for the parties. Paragraph by consent of the parties, comma. The order passed on 22nd December 2023 is modified to the extent that the sixth respondent shall forward the application submitted by the petitioner under section 3G5 of the Act of 1956 to the learned arbitrator, who shall consider and dispose of the same within 2 weeks from the date of receipt. It cannot be 2 weeks.
My lord, according to the Act, Lordship, it may be within a year, according to.
Yes.
Therefore, at the earliest.
Shall consider and dispose of the application in accordance with law upon affording reasonable opportunity of hearing to all concerned, including the petitioner / his authorized representative. Stop. Stop, Didi. Paragraph, the remaining portion of the order shall remain unaltered.
Lordship, three similar applications, similar orders.
They have not come in the list. Let them appear.
Lordship, may I forward the numbers, Lordship? I mentioned all of four analogously and served the notices.
তিনটে সেম ম্যাটার একটা এসছে দুটো আসেনি তিনটেই মেনশন করেছেন উনি একসাথে প্লিজ গিভ দ্য নাম্বারস
My lord, I'm giving the earlier order copies, Lordships.
ওই দুটোকে তুলে দিন তো জাস্ট You have not given 3 slips, 3 separate slips?
Yes, my lord. 3 slips, three notices, Lordship, I serve, Lordship.
Give the
How
number.
it missed anyhow, Lordship.
Yes, next matter.
Item 9. My lord, I am appearing for the writ petitioner, your lordship. It's a small typographical issue in all probability, my lord. In the first page of the order, your lordship has mentioned that the impugned order is dated 29 December 2023.
Yes.
However, in the second page, your lordship, in the second paragraph, it's gone down as 29 January, your lordship. It will be December, your lordship.
Right. The matter has come up under the heading to be mentioned at the instance of the petitioners. Paragraph, inadvertent error has crept into the order passed on January 10, 2024. Paragraph, in the second page of the order, comma, 29th January 2023 be read as 29th December 2023. Paragraph, the department is directed to incorporate necessary correction in the said order accordingly. Paragraph, this order be treated as part of the order passed on January 10, 2024.
Deeply obliged, your lordship.
Petitioner is directed to communicate this order to the National Highway.
My lord, NHI is
National
represented.
Highways all there. National Highways is represented. Next.
Deeply obliged.
Item J.
Maybe, your lord.
Yes.
Money was not as yet not
Direct purchase.
Direct purchase.
And my lord, second matter, my lord, that is money has come, my lord, he sent the money to the appropriate authority to the DMC office money.
Send the money to the appropriate authority.
That is
They'll disburse.
Disburse.
That is the next matter.
Next.
Wait, give me 10 first.
In this matter, my lord,
659 at 650. Yes.
In this matter, my lord, money has not yet come, my lord. At the same time, my lord, we send the matter, send contact matter. We send the proposal for the money for making money of the matter.
2
This
weeks.
matter has not come.
2 weeks.
No, my lord, 1 month. For matter.
1 month.
Let the money come because it is being proceeded.
Yes.
Yes, my lord.
I have no objection.
Inflection should be seen.
Yes. After all, they have agreed.
Affidavit of part compliance submitted on submitted on behalf of the alleged contender is taken on record. Paragraph learned advocate for the alleged contender seeks a month's accommodation to comply with the order under contempt since the required fund is yet to be received.
Yes.
Paragraph, let the matter appear under the same heading on 20th February.
20th.
Sufficient time, please.
Yes.
Next.
Next. The same.
My lord, in this
Only
matter,
different.
money has come, my lord, and we send the money to the appropriate authority.
So let this appear after 2 weeks.
My lord, as we
Only requested to provide plot-wise breakup of the revised land value.
Same order.
That is only different, nothing.
The money has been received.
money
No.
has been received. এটা তো money চলে এসেছে
এটা money চলে এসেছে।
Learned counsel for the
money আসে
part compliance.
12 লক্ষ টাকা এই যে চলে এসেছে
Affidavit of part compliance should be submitted on behalf of the alleged contender is taken on record. Paragraph, learned counsel for the alleged contender seeks accommodation for a month on the ground that the fund has been sent to the appropriate authority and shall be disbursed to the petitioner in the meantime.
Yes.
Yes.
Paragraph, let the matter appear under the same heading on same.
The same day.
Same.
Yes.
I am for the
private respondent, your lordship.
I am for
The petitioner in the main matter.
I am for the applicant. My lord, please not order, not praise this order.
You're asking for adjournment?
Not this or adjournment.
Adjournment.
Adjournment. Adjournment or not press? What are you
Not
saying?
press, not press, ma'am.
You do not want to press this application?
No.
Not press this order because this order has been infructuous.
So you don't want to press the application, right? Learned counsel, Can 1 of 2023. Learned counsel for the applicant submits that the applicant does not wish to pursue the application any further. Paragraph, in view of the above, the application being Can 1 of 2023 is dismissed for non-prosecution. There shall, however, be no other costs, urgent certificate, etc. Read disposal. Disposal.
I'm for the petitioner, my lord.
Yes.
No, sir, I'll do my report.
You're not.
Next matter. My lord, earlier occasion what they submitted is contrary to that report in the form of affidavit, my lord. They submitted that they already paid their all the compensation amount. And also award us first within due time.
Kindly have a look, my lord.
What's the report say?
Page 3.
Short for the requiring body, my lord, that is not yet received, my lord. The last paragraph.
You have sought what?
Because they have, can see my report page 3.
Page 3, first paragraph, my lord. Kindly have a look, first paragraph.
When was the award declared?
2007.
The 9(3)B was initiated.
After they are booked for dictation. That is the direction of our payment. After they have got an award declared.
That is the decretal amount after the section 18 proceeding.
But award was passed, my lord, after 11th of 1997, 31st March 1997.
There was an earlier petition which has decided this issue.
No, my lord, on that period, this issue was not raised, my lord. So just kindly come to the impugned order.
2004.
Yes, my lord. But this issue was not raised, my lord. Kindly come to page number 29 of the writ petition, my lord. The order passed by Honorable Justice Jayant Kumar Biswas, my lord. Page 29, my lord.
এখন যে ডিসিশন নিয়েছো কি কারণে সেই প্যারাগ্রাফটা পড়ো।
There was direction for payment of compensation.
Yes, my lord. If the petitioners are any one of them
And
is
the court holds that award was declared.
on that period, award was not declared. After that, award was declared. Award declared in the year 2007.
Declaration of award and payment of compensation are two different issues.
Yes, my lord. Yes.
Award was declared, compensation could not be paid because you did not turn up. That is the recording. Yes. Then the court directed payment of compensation. So there is no question about the award.
Yes, my lord.
Award was declared. Award has not been challenged. You challenged the quantum of compensation under section 18.
That is previously, my lord. Presently, the act act is non-aid. I raised this question in the 2013 act is applied now. So, my lord, 1997, if they pass the award within 31st March 1997, I have no, there is no question, my lord. So I will avoid that that compensation. But in this situation, my lord, kindly come to my writ petitions.
When is the award? When was the award declared?
But now they can raise this question.
You have said that that was the question raised by the court in the earlier order.
Yes,
The date of
yes,
declaration of
madam.
award.
Order passed by earlier petition, we have award has been declared and thereafter.
When was the award, the date? If it is beyond 31st March, 2013 Act applies. The date of declaration of award.
That is the point.
That is not in the report.
আমি তো সিনিয়রকে গাইড করছি।
Kindly come to page number 11, my lord, of the writ petition, my lord.
Yes.
Page paragraph 20.
This is your submission. The
Yes,
documents need
yes,
to be
sir.
seen.
Yes, my lord. Yes, sir.
You stated that the award was declared within the statutory period of time. Where is the date and where is the document of award? Please come back with a proper report. This report has nothing, contains nothing.
The date of award.
Yes, the matter stands on that, isn't it?
That I can instruction I can take.
Again instruction. Right? Again instruction.
And this is also not an affidavit. Please state, where is the affidavit?
No affidavit.
No, it's there, yes. Report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph. The report does not contain the date of declaration of the award. Paragraph. Learned counsel for the respondents seeks to take further instructions in this regard. Let him come back with the date.
Yes, madam.
This award contains nothing.
Yes.
This report. Paragraph. Let the matter appear under the same heading on 19th February.
I'm good.
What will afford the report on this point? Next. Yes, so this is your matter. Yes.
May it please your lordship, my lord. I'm for the petitioner, madam. In item number 14 to 18.
You are appearing for?
For respondent number 11, lordship, Reni Bhattacharya is appearing. If not,
One minute. Shugant, I'll just on the earlier date, my lord, the learned advocate for the Eastern Dedicated Freight Corridor, my lord, used an affidavit. So, my lord, I'm supposed to give an exception to that, my lord, report. Because, my lord, here, my lord, I pay for, my lord, compensation, meager amount which has been paid. I pray for enhancement, and as also, my lord, I pray for that
Employment also.
Yes, as well. So, my lord, they have relied upon some document, my lord. I was supposed to give an exception to that, my lord. But what happens, the mother of the petitioner, my lord, passed in this meantime and he could not come and affirm this. So, my lord, I just need a time, my lord, for extension for this exception, my lord. All in item number 14 to 18.
Mr. Dey is appearing for the state. Well, I am for the Eastern Railway authorities.
And also against the affidavit of my learned senior friend, Mr. Dey.
Yes, DHN is there. Mr. Dey is not aware.
But what happens here, my lord, since there are, my lord, 5 matters together, my learned senior is appearing, my lord, 2 or 3 matters. So this is why.
So, no, in this matter, Mr. Dey is appearing.
Yes, it does.
কি হচ্ছে অম্লান? Mr. Dey নামটা দেবো। আজকে 5-6টা কারেকশন পাঠালাম, সব আপনার টাইপ করা। বাড়িটা একটু পরে বাড়ি যাবে। Learned counsel for the petitioner seeks extension of time to use an exception to the report in the form of affidavit to the reports submitted on behalf of the respondents.
Madam.
Now, to the reports submitted on behalf of the respondents.
Yes.
Paragraph. Learned counsel for the 11th respondent also seeks accommodation. Paragraph. Let the matter appear under the same heading on 21st February.
Grateful. Great.
Please serve an advance copy in all the.
I'll do that. Grateful, your lordship.
Let me call one by one because
Yes,
the state is different.
Yes.
The same set of counsels, same order. Same order. Same. You have filed your report. Same order. Same order.
Grateful, madam.
19.
May I take your lordship leave, madam?
19. In this matter, my lord, this second page, my lord, the order passed in the early, in respect of the earlier writ petition, page number 237, my lord. There were some anomalies regarding paid of compensation. Your lordship directed to consider the representation. Representation, my lord, submitted, page number 237. Thereafter, my lord, rejected without any reason, my lord, on the basis of the rate indicated that the government of West Bengal rate already fixed. On the basis of that rate given, my lord. But in the same moja, same plot, we are the same footing standing, my lord, not given. And my lord, not asked to the government representative. Your lordship earlier allocation directed to
37 is an advertisement.
237, my lord. Kindly see the last order, my lord, directed to add the land acquisition department, my lord, file a report. Earlier order passed for file a report by the government of West Bengal to ascertain that on the basis of which, my lord, the compensation was fixed in respect of the land of the petitioner. 237, my lord, represent order is a 239. Earlier order and present order, my lord, kindly see. Your
The
lordship.
order impugned.
On the basis of the on the basis of past merit petition disposed of, directing to consider by filing the representation by the petitioner. I file a representation 237, disposed of, order passed 239 by the department. Thereafter, my lord, earlier allocation writ petition came up before your lordship. The lordship directed to file a report by the representative of the government of West Bengal, Land Acquisition Department.
Yes, who is appearing for the state?
Lord,
My lord, I appeal for respondent number 4, my lord. The corporation.
Mr. Protocol is appearing. The report?
Report today is not ready, my lord. Directed to the state, my lord, to file a
Yes,
report.
yes, right.
I'm speaking my more time, my lord. Lord, kindly see the when, my lord, matter was heard by your lordship. Incorporated the, my lord, subsequent respondent, as per your lordship directed.
The dispute was disparity between payment
Yes, ma'am.
of adjacent owners and the petitioner.
Yes, yes.
So you have to clarify,
We are-
clarify that point in your report.
We are seeking same blood compensation.
My lord, may I please? My lord, the principal contention of the petitioner herein, my lord, is principally on 2 points. One is, my lord, that Section 3 notices were not served, and number 2, my lord, the determination of the amount of compensation. Your lordship, in the previous writ petition, respondent IOCL has, my lord, filed one affidavit report in the form of affidavit, my lord, disclosing therein that the Section 3, all the Section 3 notices were served upon the petitioners therein, my lord, which included this petitioner as well. As also, my lord, one, determination of the compensation amount of the competent authority, my lord, which, my lord, demarcated the amount of compensation according to the, my lord, lands in question. My lord, the classification of lands in question, your lordship. My lord, firstly, my lord, determination of compensation under Section 10, my lord, has also got an alternative remedy under Section 10(2) of the Act, my lord, which, my lord, the petitioner did not avail. Be that as it may, my lord, if your lordship kindly directs us, we can praise and disclose the, my lord, the compensation which has been provided, my lord, the details as well as
Lord,
the
regarding maintainability, my lord, the earlier writ petition or several allocation heard, thereafter, my lord, decided to thereafter, my lord, file passed an order. Lord, my submission only, my lord, to file a report if we are standing in the same footing to pay the same compensation, my lord. Only that, my lord. Nobody will prejudice. I am apart from this.
My lord, my lord.
Let's see
As
all
your
relevant documents.
lordship.
Let the IOC also come back with a report.
Come, let me.
And does your report disclose all the details?
I think that it will not prejudice any parties, my lord. If my innocuous prayer, my lord, standing in the same footing, other, my lord, got compensation.
It has to be seen whether you stand on the same footing.
Yes, my lord. Same moja, same dag number.
It's your submission, let the authorities also decide.
Yes, my lord. But that's why, my lord, earlier occasion, my lord, you'll also directed to file a report. By disclosing it is the same moja, dag number, we are on the same footing or not.
My lord, they also have an alternative remedy under Section 10(2) of the Act, my lord.
There are
They could
several
have
recent
availed.
judgments of the Supreme Court that even in case, you're aware of the judgment.
My lord.
After
There is no
considering other order
complicated question of fact, the writ court can decide.
Yes, my lord.
I don't think there is any complicated question of fact in this matter. Anyway, come back with your
Lordship.
Please annex all the relevant documents.
My lord.
Learned counsel for the state respondents seeks extension of time to submit the report in the form of affidavit as sought. Paragraph, learned counsel for the Indian Oil Corporation also seeks to submit a report in the form of affidavit annexing relevant documents. Paragraph, let the matter appear under the, please serve advance copies.
My lord,
Yes,
kindly
lord,
grant
kindly
4
indicate.
weeks, my lord, for my lord.
Kindly-
My lord, kindly grants 4 weeks.
Lord, kindly indicate
Panel
before my lord,
of service.
advance copy should be my lord, kindly indicate.
Very well, 20th February.
Lordship.
20th February.
20th February, March. In the same heading. Lord.
Yes. Next.
I'm for the petition receipts. But this matter was, Lordship, the impugn order was asset, impugn order passed by the Principal Secretary Department of Industry. And Lordship was, last occasion was directed my learned friend to take an instruction whether the plot has
been auctioned or not. Lordship, we have taken instruction. See, the thing is, previously, when the auction was conducted by the district administrator, it was done based upon the plot number. In a plot, there might be several sand blocks, but presently they are auctioned, the sand blocks are auctioned by way of geo coordinates. So I have checked up these particular geo coordinates not there in the, but I believe it has not been auctioned.
So, the Lordship, the order impugn passed by the Secretary is challenged, which is the force majeure clause mainly particular that they have not been disclosed. On the last occasion, Lordship State has been.
No, Lordship, sir, passed by the Principal Secretary, not by the district administration.
Principal Secretary, this
Principal
is not
Secretary.
the applicable order.
Lordship, on the last occasion, Mr. Bandyopadhyay appeared. Possibly, he asked for
Affidavit.
direction for affidavit because the detailed order has been passed by the Principal Secretary.
No details orders have been passed.
Details order passed.
No. This is the challenging. No,
Where is the order written?
Lordship, come page 108.
100?
108. 108. 108. Lordship, if you Lordship come the directly the
You asked for extension.
no Lordship, I am asking. Obviously, I am asking
Extension on
the
intervention of
COVID period, and the force majeure clause which has been should have been invoked. They have not properly dealt with, and the learned friend asked for filing affidavits. So they can file affidavit, but in the meantime, the plots should be Lordship
Where is
protected.
the, what ground is, where is the?
Lordship, kindly come the directly page 109, paragraph 9. Now, after careful consideration, the representatives of the petitioner, the written arguments stated above records the department. They found that the department has already allowed one-time extension to facilitate transaction to new sand mining policy dated such and such, and the notification dated MOFC mentioned in the petition has provided. Lordship, this notification which Lordship I am showing the
Where
page.
is the remaining part of the order? This is incomplete.
No, this is the complete 9 and the 10. Last is the 10.
10.
Oh, in block letters.
Lordship. So only that notification they have referred, which has on the, in the year 2002 only 3 months were extended for 3 months. Those the lessee have Lordship, Lordship, those are lessee have expired till the April 2002.
Yes, 2022.
2022, sorry. Only that notification has been referred in this impugn order, and therefore my application, my representation, my prayer has been rejected. Without any invoking Lordship force majeure clause as well as other grounds I have taken 105.
Where is the earlier order of this court?
Earlier order is at page 84.
Page, no, 97.
Earlier order, প্রথম যখন
No, first,
আচ্ছা,
the second first.
second order.
Page 97.
97.
Lordship.
This is a second writ petition.
Second writ petition. First writ
But
petition
there is specific direction in this, only to
only to dispose of my representation in view of
order previous to that.
Lordship.
Previous order is at page 84. The first writ petition, order passed in the first writ petition.
Page
Because there the court must have mentioned the.
Initially, it was relegated to the ADM.
Lordship,
for
kindly come to page 89. The first writ petition and my lord,
This is
the
the
first
adjudication by the
ADM order
ADM.
was passed by ADM. Page 89. And they have clearly stated, Lordship, if you see, Lordship, kindly come to page 90. It is further evident from the office that the concern of the applicant has already been sent to the industry department by citing the grounds of force majeure clause such and such. In view of this, it is evident that power of consideration of issue rests with the state government. Second, the issue has already been communicated to the import authority. The ADM has itself has sent to the Department of Industry.
এবার আমি বিচার করতে হবে আমরা
And therefore, Lordship, we have made an application for authority and they did not consider we should.
These 2 points have not been taken into consideration.
Lordship, this is the only ground in my writ petition. This writ petition.
Please come to page 86. The authority is
86.
directed to take into consideration the memorandum.
Lordship, yes,
And clause 5. This has not been discussed at all.
no, nothing. Never discuss in any matter. There are several matter I have done, but they are
client. ADM যখন অর্ডার করেছে এগুলো কনসিডার করেনি। আবার সেক্রেটারি কাছে পাঠাবো নাকি?
Lordship, ADM has not considered and that directly is sent to the Department of Industry. A department has passed this order.
Till then it was all right.
Lordship.
Because he says he doesn't have the authority.
Lordship.
But the principal secretary should have considered.
Nothing has been mentioned. Even I have written notes on my argument. I have specifically stated that they have heard it. But during passing order, no such, Lordship, the whispering about my force majeure clause or anything.
You were heard by the authority when the.
Lordship,
You were heard by
it was heard. Lordship, Lordship, kindly see paragraph 9. Now, after careful consideration, Lordship,
Yes.
written arguments as well as records.
They've referred to the 2022.
Lordship,
February
that
2020, yes.
that we have done.
Not the 2020 or
No,
the.
nothing.
Yes.
Force majeure clause.
Reconsideration. Mr. Bandyopadhyay, let there be a reconsideration. Order has not been complied with at all. Let this be set aside, let it be reconsidered within 1 month.
That is will be better, Lordship.
It will be better, but I'm afraid the fate will be the same.
Then it will be unfortunate on my
I now
on the part
we
my
have written
petitioners.
what the authority does.
Lordship.
Let us take a chance. The order passed by the Principal Secretary, Department of Industry, Commerce and Enterprise on 10th January 2023, turning down the representation submitted by the petitioner for extension of the mining lease is assailed in the writ petition paragraph. By an order, paragraph, by an order passed on May 11, 2022 in WPA 5969 of 2022, this court directed the concerned authority to consider and dispose of the representation submitted by the petitioner after taking into consideration the memorandum dated 13th May 2020 as well as clause 5 of part Roman 9 of the deed of lease, and after giving reasonable opportunity of hearing to all the interested persons, including the petitioners, comma, in accordance with law. By a subsequent order passed on August 26, 2022 in WPA 18890 of 2022, comma, this court directed the authority to consider and dispose of a further representation submitted by the petitioner dated July 8, 2022, upon granting reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Paragraph. It appears from the order impugned that the observation / direction of this court passed in the order dated May 11, 2022 has not been taken into consideration by the Principal Secretary in the order impugned. Stop. The authority has turned down the request of the petitioner by the impugned order on the basis of the new sand mining policy dated 28 February 2022 without considering the other issues raised by the petitioner before him. Paragraph in view of the above, comma, the order impugned dated 10 January 2023 be set aside. Paragraph, the concerned authority being the respondent number,
Lordship, 2, Principal Secretary 2.
being the second respondent here in comma, is directed to revisit the issue and pass a reasoned order upon affording reasonable opportunity of hearing to all concerned, including the petitioner, and in the light of the observation made by this court in the order passed on May 11, 2022 in WPA 5969 of 2022. Comma, within 1 month from the date of communication of this order, comma, in accordance with law.
Lordship, till the disposal of my this communication, this order,
No third party interest will be created.
Lordship, kindly.
It has not been put into auction.
Because what happened, Lordship, they heard it on a day and they communicate the order after 3 months, 4 months, 6 months, whatever.
No, I'll record that. I'll
I'll
record 7 months, 7 days. Yes. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, pending disposal of the representation, comma, no third party interest shall be created in respect of the plot in question.
Lordship. Great.
Disposed of which actually?
Great.
6 weeks. Very well. 6 weeks. ওইটাকে আগে দিই না
Great.
তারপরে upon না না
ঠিক আছে এটা
within 6 weeks এরকম করে না করে upon affording civil opportunity.
My lord, item numbers 21 and 22.
Let it be called. Yes.
My lord, item number 21, my lord, I am seeking for one month's time, my lord, because we have not yet received instructions
You are appearing for?
for the petitioner.
I'm for the
Your case. It is your case and you have no instructions.
My lord, instructions with regard to that possibly talks of set.
Your Lordship, if I
going
may, Your Lordship,
You are appearing for?
I'm appearing for the petitioner. I'm with him in this matter, Your Lordship. In both of them are connected matters, 21 and 22, Your Lordship. I'm the advocate on record in the next matter, Your Lordship. The issue is that this is essentially an application challenging the order of the competent appellate authority under the Metro Railways Act, Your Lordship. We need certain instructions, Your Lordship, as to whether we need to proceed with the matter or not.
Very.
Because if Your Lordship, can you adjourn it for 1 month, Your Lordship? Absolutely, absolutely.
Actually,
A report was called for from you, I think.
no, I'm submitting it. According to their pair, the interest was not given under the 2023 Act. But actually, appellate authority passed an order awarding higher amount of rupees 6,59,259. And
including interest.
Solicitor interest form. Just you look at page.
A report in the form of affidavit was called for from you. Anyway, let the petitioners come back.
Which I am submitting by the call. We have requested them to collect the money, compensation money, and hand over the position.
That's why a report was called for, sir. You're not ready with your report. A report in the form of an affidavit was called for from you, from the authority. Let that be submitted on the next occasion. And the petitioner is also seeking time. In the form of an affidavit, annexing relevant documents. A learned counsel for the respondents seeks extension of time to submit the report in the form of affidavit as called for. Paragraph, learned counsel for the petitioner seeks accommodation to take further instructions in this matter. Paragraph, let the matter appear under the same heading on 22nd February.
Deeply obliged, Your Lordship. Deeply.
In both the matters, the same order is.
Both the matters. Deeply obliged, Your Lordship.
Same order. Petitioner? Anyone for the petitioner? 23? Dismissed. Petitioner? Yes. Yes, what is the matter about?
But
Yes,
the land has been taken, but the
land has been.
acquisition, but the compensation has been granted under section under 1894 Act, but it has ought to be granted under the 2013 right to fair and compensation.
When was the award declared?
Yeah,
When was the award declared?
one award declared.
Why are you claiming under the 2013 Act?
But it, section 11 and section 24 is yes, they have been piloting.
When was the award declared?
One award declared in the last year. But kindly keep it Passover, my lord.
Passover is not possible in this court.
But then kindly keep another date, my lord.
Yes?
Kindly keep another date, my lord. The council is.
Not necessary. Affidavit in opposition is not necessary. You can at best come back with a report. Yes, will you come back with a report? Yes? Let them come back with a report in the meantime. Affidavit of service. Paragraph heard learned counsels for the parties. Paragraph learned counsel for the respondents seeks to submit a report in the form of affidavit in this matter. Paragraph let the matter appear under the same heading on 22nd February. 22nd February. 22nd February. Next.
25 years. When you directed the authority concerned the second time to dispose of our dependencies. The matter, the land was taken for oil affected trial. Then that was considered. Then you also can see on the operative portion, page 49. Page 49. Last paragraph. They agreed that has been calculated 36 lakhs an order. Hence, the matter is disposed by requesting the principal secretary such and such to place the state fund as well maintain the proposal direct purchase plan, such and such, the soonest possible for giving effect to the direct purchase of the land in terms of the existing guidelines. The petitioner and all the concerned officer will cooperate and take all necessary. That order was passed on 7th February 2023.
Not implemented.
No, then I sent a notice to the secretary. Next page. On 15th May. They have that sitting tight. Everything has been done.
Affidavit of service.
2 months.
Affidavit of service. Pursuant to an order passed by this court on 25th November 2022 in WPA 9153 of 2022, comma, 2022, comma, directing the concerned authority to consider and dispose of the representations submitted by the petitioners dated 15th November 2018 and 8th March 2022 respectively within a stipulated time frame, comma, the
Last page, page 46. Page 47.
Secretary and LRC, comma, Land and Land Reforms and Refugee Relief and Rehabilitation Department, comma, by an order passed on 7th February 2023, requested the Principal Secretary, comma, Irrigation and Waterways Department, comma, Government of West Bengal, to place the fund as mentioned in the proposal for direct purchase of land sent by the Executive Engineer hyphen Roman 2, comma, Joynagar Division, VDA number 748 hyphen EII, capital 11, dated 12 July 2022 and number 48 hyphen EII, dated 13th January 2023 at the soonest possible for giving effect to the direct purchase of land in terms of the existing guideline. Stop. The petitioner and other concerned officers were requested to cooperate and take all necessary action in this regard with due priority. Paragraph learned counsel for the petitioner submits that despite such order, comma, no step has been taken by the Principal Secretary, comma, Irrigation and Waterways Department till date. Paragraph. Learned counsel for the respondents submits that the fifth respondent be directed to
Respondent. Yes, please.
act in terms of the order dated 7th February 2023 in accordance with law.
Yes.
Paragraph. In view of the above, the petition is disposed of, directing the fifth respondent to act in terms of the order dated 7th February 2023 passed by the Secretary and LRC, Land and Land Reforms and Refugee Relief and Rehabilitation Department, and complete the entire exercise of direct purchase within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned. No further.
No. Because that already decided 36 as an odd.
That is decided already.
Yes.
So,
That
so no
amount,
further opportunity is required.
but that amount pays 48. 36
Yes.
55,000.
3 lakh.
That is
5,580.
That is decided amount.
They have already valued. But mention that amount. That has been mentioned. Amount
on record, no need to mention. Sir. I have only asked for taking action in terms of the order.
Yes, for paying that.
Within 3 months, yes.
Only 3 months. The paying that amount that has been calculated, that has been determined. Only can add that line.
Entire exercise data key bola. A direct purchase, including disbursal of the amount of rupees.
36 lakhs.
Page
5,000. Page 48. Above hard all. That the valuation calculated was
36 lakhs 365580.
That is 5580. Yes. 36 divided by 80. Yes. 5,580.
As zero as as assessed by the authority. Within 3 months. Disposed of exactly. Next. No.
Maybe not. This matters. Land was acquired under Act 2. The page 27. We came to this number court. This on page 27. Can you see? Kindly. Page 27.
Yes.
That order was passed on 21st November 2019. But I am placing only order in question concerning the service of the parties, the requisition is disposed of by requesting respondent number 2 to consider the appropriate representative strictly in accordance with law within 12 weeks. Then, my lord, come on the person to said order, page 29. The district merchant collector heard the matter and the petitioner appeared. They were not. Order number 3, 18th February 2020.
Yes.
Today being the date of hearing, the case is taken up for the same as notice. The notice duly served, representing the requiring body, that is PW Road, or the representation are present today, while Hajira certainly verified the representation till 8 January 2018 and 1st February 2018. It is which were found annexed to the petition. It appears from the content of the same that the petitioner was claiming compensation under the Right to Fair Compensation Act, or in other words, new Act 2013 for acquisition of the case certain. In this regard, it needs to be mentioned the Honorable Supreme Court of India, in order to that passed in SAP certain but in the development that way. Enter that at that point of time, there's an interim order. It has been quoted. Then, under the above facts and circumstances and in the valued observation, except the Honorable Supreme Court of India stated above, since the pair of the payment of compensation was made under the new Act 2013, which is pending for consideration before the Honorable Supreme Court, thus undersigned is unable to pass any order disregard till dispose the matter by the Honorable Supreme Court of India. Hence, the representation.
So this has been disposed of. This has been disposed of.
No, I challenge that order. Then I came to your Honorable, your lordship passed the order. Next page, page 31. How does it?
Yes.
It is submitted under the petitioner that pursues the direction of this court. The petitioner submitted petition before the concern of pleading for payment of compensation in view of acquisition of land by an order dated 18 February 2020. The concern was that being the district estate collector to for the south set aside or dispose of the representation of the petitioner with an observation. The PR for payment of compensation under the right to fair compensation and transparency land acquisition, rehabilitation, and resettlement act 2013 is pending for consideration before the Supreme Court, and the authority may consider the representation for the same reason. It is submitted on behalf of both the parties. The matter has been set aside, set at rest by judges of the Supreme Court. The petitioner pays for direction upon notice for reconciliation, the representation submitted the petitioner. Then, madam, in view of the same, the writ petition is disposed of, directing the second respondent to reconsider the representation submitted by the petitioner before the authority and dispose of the same within a period of 2 months from the date of communication of the order. After affording of a reasonable opportunity of hearing to all the interested parties, including the petitioner in accordance with law. As the petitioners are very vital, are interested in direct purchase of the property in question by the state respondent in terms of April Sergeant Sir, date 25th February 2016, the concerned authority may consider state proposal of the petitioner in terms of the memorandum date 25th February 2016. That was your lordship direction. They did not say anything. That was not, they are not challenged that. Then, my lord, they, because next place there's some personal concern, you are also interested that they have been added. They will also be heard by the authority. They are not the parties here. Now, my lord, then, personal your lordship direction, page, your lordship comes to the page 37.
Yes.
Start from 37, that is 30th January 2023. That your lordship's order to the mention. As the quoted, the lordship's order. As a petitioner that interested in direct purchase of the property in question such and such, the concern will be concerned with this proposal, the petitioner in terms of minister and such. Later is, I am not concerned with that. Then, my lord, the lordship comes. Next page, page 31. 38. In compliance with the order dated 14th March 2022, the proceeding is initiated on the true verification incident petition. The petitioner have claimed compensation to following Muda. This is mentioned. Number 1, writ petitioners. 2. 2 is the now your before your office petition number 1, 5, 3, 4,
5, 6, 7.
5, 6, 7. They are now before your office. Then your office come to the next page. Next page order. On verification of the application order passed by such and such, the Honorable High Court, Calcutta, in respect of WPS such and such, it revealed that applicants, namely Radharan and SUVRA such and such, jointly claim compensation. The next paragraph. Whereas on occasion of the requisition being Dr. such and such, it appears the land acquisition proceeding being area number such and such under provision of original land acquisition requisition Act 48 hearing after referred to as Act 2 of 1948 was initiated for the purpose of construction highway from the point of Jibon Mondol hut under Joynagar such and such under Kulati police station on the request of Superintendent Engineer PW Road being the requiring body. But no compensation was paid either to the petitioner of the petitioner or to the petitioner. On through verification of the available office record is transferred, the suit report mentioned above are proposed for acquisition in illegal circumstances by using requisition under 3.1 of West Bengal Circumstances Act 2, and possession was delivered to the requiring body on 3rd May 1976, followed by gazette notification under 4.1A published on 8th March 1979. File number Sarjansa dated 3rd August 1978. The said land acquisition proceeding could not be proceeded further. Subsequently, the LA case was divided by using notice 93B on 4th August 2010. An award was prepared on 21st June 2011. But LA proceeding could not be completed due to non-placement of fund by the recording body. Now, in compliance with the past circumstances, notice to all the petitioners and the petitioners, including representative requiring 15 date of hearing, 10th February. Next one. Third, the case of Subject heard the report of the joint field inquiry conducted is also taken up for consideration the part of the case proceeding. But no inquiry report was submitted to the petitioner. The hearing also. Here also can you see run over next page, page 41. The first part I am not indicating that as per direct purchase policy, there's the agreed your loss is directed to make consider. Second, the order of Constitution bench of Supreme Court of India said 6 March 2020 passed in such and such in the matter of Indo Development Authority versus moral order is pending and taking into consideration for proposal for disclosure proceeding. It depends from paragraph 363 of clause 2 of the said order of the Honorable Supreme Court of India in case of award has been passed within window period of 5 years, excluding the period covered by an interim order of the court, then the proceeding shall continue as provided in section 21(1)(b) of the new Act 2013 under the Act of 1894, as if it has not been repealed. On verification of the record of education scheme such and such, it appears that award was prepared under section 11 of the Act 1 of 1894. After issuing notice under section 93B and was duly vetted by the government on 16 June 2011. Hence, the instant proceeding will have to be dealt with and concluded in the light of the above order of the Supreme Court of India as per provision of section 24(1)(b) of the Right to Judicial Act. The details of the award passed to the district master collector against the petitioner are furnished below. Now, that was 2011. They could not place. That is admitted. When we came to the Honorable Court, your lordship, they did not say anything. Anything. Only may consider the direct purchase of it. First, that was dismissed. In the second order, the first order, they already discussed Honorable Supreme Court judgment. Now nowhere in the petition whether they can consider your lordship direction for direct purchase policy. Then, my lord, your lordship can see they have calculated page 45, ordering court, sir. Also the last paragraph. In view of the above finding as derived from the existing official record, it is thus concluded that as per order of the Supreme Court of India, the 6 March 2020 passed such and such in the matter of Indo Development Authority such and such, the LA proceedings are treated as not lapsed, and all the above eligibility petition and the writ application entitled to get their compensation in accordance with the award passed against their name with respect to concerned suit brought as per statute, except brought such and such. The award in respect of suit brought such and such. Second paragraph. Hence, in the light of fact, is hereby ordered the compensation to be paid to the such and such. Jyoti such and as per award being as per his award is serial number such and such. It has been mentioned by serial. Against whom award was passed. Then, my lord, page 47. Yes. Last part. These are layers of Sindra Saka would be paid compensation side. We are not concerned. They are not the requisition here. Hence, the representation of all applicants of the requisition are hereby considered and disposed of in compensation of. In view of the Supreme Court judgment, now they are saying. But whether there is nothing, no whisper, they can unable to consider the direct purchase policy, did not consider. But your lordship direction was may consider for direct purchase.
What was your proposal?
We did not reconsider. First, this talking about the Supreme Court. What occurrence is this order? 2011, they are sitting tight. Since we came to this Honorable Court, now they are saying everything. Yes, that was prepared, nothing. Now the Honorable Supreme Court tried.
But acquisition proceeding was initiated. So so you have to stick to that. You cannot go in for direct purchase simultaneously, isn't it? There cannot be two parallel proceedings.
No, I was not that for the this order. It appears that was passed in the 2011. We are in the totally dark. Previously, 2 times we came here.
You have received compensation for this?
Yes, 2 times here.
You have received the compensation?
No, nothing. What compulsory are the not I old act? Then I can bring the another judgment. I got honorable division bench 2013 act. Man, I shall bring your lordship. Then I got. Then
Will you come back with a report with regard to all these instructions? Not necessary. A report in the form of an affidavit. Just the documents are required.
yes. And I shall place another the division bench judgment 2013 act. But director no. That land was acquired under Act 2 also. That everything was argued. That is why he said no. You pay Constitution Act 2013 Act. And Supreme Court said that was the place before the honorable division bench. I can place your lordship. I got it.
It is to be seen whether the award was declared within the stipulated time frame and payment notice was
Yes,
served.
submit a report.
Yes, that's why.
Submit a report.
The required
Yes.
documents need to be.
Including an inquiry report also. Because it is spelled out. That's the inquiry report. Joint inquiry report.
All the relevant documents.
Including inquiry report.
Affidavit of service. The petitioners claim compensation in terms of the right to fair the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act, 2013, or alternatively, direct purchase of the plots in question by the state respondents. Paragraph, learned counsel for the state respondents seeks to submit a report in the form of affidavit in this regard, annexing all relevant documents.
Yes.
Paragraph, let the matter appear at the same heading on 22nd February.
22nd. Huh?
Next.
Into all both, yes. Very good.
Well, 10(1) of the Highways Act is under challenge. Kindly see page 23 first.
Page 23, yes.
Page 23. This notice was issued under section 10 subsection 1. Now, madam, kindly see the subject. Has you also got it?
Yes, yes.
Unauthorized construction of the government PWD land plot number 1850 and 1848. Records, I have got this record. The land belongs to the local board. Now, the land in the nature of non-Jew. Now, can you see section?
You will have your opportunity before the authority itself under section 10(3).
No. I am challenging the notice, but these have got no jurisdiction to issue that notice. Why I tell you not see? Kindly section 2B
of
the Highways Act. Kindly see. The Highways Act 2BB.
Yes.
Government road means a road vested in the government or under the control and administration of the public works department of the state government and includes such and such.
Yes.
No, section 2C. Highway means any road, street, pathway or land other than the national highway within the meaning of the National Highway Act, which is declared by the state government to be highway under section 3. Now, kindly see the judgment of my Lord Justice Jyotirmoy Bhattacharya. Kindly see the judgment. No, internal page 4. Kindly see.
Yes.
Section 3 of the said act provides that the state government may by notification in the official gazette declare any road, street, pathway or land as the highway. This declaration, in my view, is necessary only when the state government wants to declare any other road, street pathway, etc., as mentioned in section 2C as pathway. In addition to the government note as referred to in section 2BB of the State Act. In my view, no declaration under section 3 is necessary in respect of the government note, which itself is a highway independent of any such notification in view of the provision. Therefore, government, in case of the government note, section 2BB, no notification is required. But in case of 2C,
Judgment.
judgment copy this. Section 2C, the notification is required. This is the judgment. 2C is that, my lord, defined apart from the government road, any road, any pathway, any land. In that case, section 3 is required for notification of the, because you want to make a highway in respect of the land belonging to local board. Now the notification is required in view of the judgment. And section 3 kindly see. Section 3.
Where is the averment that they want to make it a highway? It is already a highway, state highway.
Cannot be. Without notification, that cannot be.
Can be. Please come to the next paragraph in the judgment that you are referring to.
Yes.
In my view, no declaration.
No declaration in respect of the government road. Kindly see. Kindly see.
Which is itself a highway.
Kindly see.
Doesn't need
In my view,
Yes.
in my view, no declaration under section 3 is necessary in respect of the government road, which itself is a highway independent of any such. In my view, the provision contains section 2C read to section 2 of the Act. Just earlier paragraph. Earlier paragraph clear. Section 3 of the State Act provides that state government may by notification the official agent declare any road, street, pathway, or land as highway. These declarations, can you note that? In my view, is only necessary when the state government wants to declare any other road, street, pathway as mentioned 2C. Kindly see. Therefore, in case of 2C, notification is required. In case of 2BB, no notification is required. Because this is not the government road. This land in the nature of non-jury. That will be coming under the purview of section 2C of the Act.
This is a government road within the administration of the Public Works Department, 2BB.
The nature is the non-jury. Kindly see. This nature is the non-jury. This is coming under the purview of section 2C. That's why the lordship has been pleased that the notification is required in case of section 2C, not in case of section 2BB. That's why the lordship is desired there. In case of government road, this is automatically government road, which is under the PWD. And therefore, this road, and therefore, this is my first submission, because in case of 2C, notification is required. This lordship clearly. This declaration, in my view, is necessary only when the state government wants to declare any other road, pathway, etc.
Whether the petitioner is a party in these proceedings. The petitioner who came before this court to obtain that order. In pursuant to my lord's order, the proceeding has started.
Yes. Yes.
That petitioner is perhaps not made a party in
Not
this.
necessary. He is the alleged encroacher who is challenging the notice itself. The 10-1
He
notice.
initiated the entire proceedings.
Yes.
Number one, he is not made a party.
Even in his absence, it can be considered.
Because the notification is challenge. Yes.
10-1 notice.
Yes. And first submission, second submission, my lord, kindly section 5. First of the country, the highway authority definition, section 2D. Highway authority means the authority appointed under section 5. And section 5 is, kindly see, the highway authority, no person shall make, sorry, the state government may by notification the official can appoint one or more officers to be highway authority. So, but here also, no gazette notification so far the highway authority is concerned. I have the two more submission. You did not comply with the section 3 because section 2BB is the government road. No notification is required as per his lordship judgment. But section 2C, apart from the government road, any other road, land, pathway, in that case, notification is required. Section 3 has to be complied with. That has not been done. This is my first submission. Second submission, the highway authority, as per section 2D, highway authority has to be gazetted under section 5. Section 5, the state government, by notification, appointed the one or more officers as the highway authority. But that has not been done in the present case. The notification has been issued, assistant engineer. That assistant engineer has not been gazetted by the gazette notification. Therefore, he has got no authority at all. These two submissions. And that's why he lost had to clearly held. You know, in case of section 2BB, it is not required. But 2C, notification is required.
There is a similar judgment passed by the same honorable judge, where it is said that the notification it's technical and it is not mandatory. I have not really, I have to.
Well, I'll come back with that. That is perhaps reported judgment.
I think it's a reported
My
judgment
lord
where
is
the same
referring
honorable judge has
to
said
judgment.
that it is only technical and the illegal encroacher cannot get a protection on that ground. I think that judgment
No
is
locus.
required in this case. No locus.
No locus.
That is reported judgment. That is reported
I
judgment.
think it is a reported. I cannot recall at the moment. Will you please help me, Mr. Dhar, with the
Yes,
judgment?
my lord, I'll come back with that judgment.
Other occasion when Mr. Datta is other side, when I was when I represented the.
You have placed that GSES.
No.
It's Justice Bhattacharya's judgment. The other judge-
That is reported judgment.
Yes. So please.
But Justice Jyotirmay Bhattacharya.
Yes.
So report
Same judgment where he says otherwise.
And my lord, this I have handed up the my lord, the instruction.
Yes.
And my lord, from the report, my lord will find that this is under PWD. Initially, it was with the other division. Now the other division is taking care. Everything is there. So what Mr. Dotto is relying only record of rights. Record of rights does not state the picture of today. He wants to take the point of it's still showing as non-Julie, hence you cannot.
Then he has to show this is a government road. Then I will be out of the court.
I'll show, my lord. I have given up the handed up the copy.
Have you
From my lord, we'll get.
served a copy?
Yes, my lord. I'm doing it here and now. What are they?
Where is the document that you're referring to? Where is the document that you're referring to? That it has been handed over to the present authorities?
After the sketch map.
Yes, after the sketch map.
আরে প্রদীপ ভট্ট judgment তো এই তো প্রদীপ ভট্ট judgment এটা তো এই judgment দেখালাম জজ স্যারকে দিস judgment I have shown প্রদীপ ভট্ট judgment this judgment I have shown to your lord আবার কোন judgment দেখাবি মানে he is telling about this judgment I have commented this judgment আর কি judgment দেখে বলছি প্রদীপ ভট্ট judgment
May I come back?
Please do that. Yes. Let him come.
In the money status should be maintained. The status could be maintained.
First page. Just first page of my instruction.
Yes.
Last paragraph. The concerned government PWD land of plot number 1850 and 1848 in front of LR plot number such and such. PS Mondarmoni such and such is adjacent to the Dokhintola Dodondo Patro Road. This road was handed over to Komluk Division PWD on such and such date.
Adjacent to the road. It's not the road. Yes.
This is a service road for the maintenance of the PWD road. So
therefore, this is not the government road.
He can't say that this is no more a road.
This is not the government road. This is adjacent to the.
Then, Malad, I'll use an affidavit.
This is PWD road.
Then I'll
this
use
is
an affidavit.
adjacent to the road, PWD road. This is instruction. This is not the PWD road. That is the distance.
My reading is this is the PWD road.
You cannot because your report says this is adjacent.
The plot number
One.
in the
Now, let's kindly come to the sketch map. 1850 and 1848.
What does the repetition say?
Sketch map টা আসুন
কোথায় আছে এটা পেজেন্ট করতে পারবো
কাগজ নিয়ে পাঠিয়ে দেবো।
কত
এটা এই জায়গাটা এই আগের পেজ, জাস্ট আগের পেজ। হ্যাঁ
The road is Dag number 1852. Does the notice reflect the plot number?
Kindly see 1850. Kindly see. This is not PWD road. Kindly
The unauthorized construction is in plot number 1850 and 1848.
1850.
50 and 1848. These
Kindly
are
see
the
1850. No PWD road.
and the report says the PWD land is 1850 and 1848. So there is no anomaly. There is
No. Kindly see this case map. 1850 is not the PWD road. There's sketch map. It's 1850. দেখো
Yes, the adjoining road is 1850.
adjoining. That is
also
No, that
this
is-
and this both
no.
are PWD
But
roads.
PWD road and some plot is
That's a
adjacent to
link.
the PWD road.
That's a link.
That is not the government road. That is not the government road.
Sir, I'm sorry,
Government
the
road is
court
definitely
cannot
link.
help you in this writ petition. If you want to come back further with instructions, you can. Please try to get hold of the judgment. Let him come back, but I don't think the court can help you in this matter, sir. It is all that you're submitting is on technical grounds.
But
Nothing on
because
merits.
section 3 and section 5, I have the two submissions. Section 3 and section 5. Because the judgment is very much clear. In case of section 2C, notification is required. What is the notification?
The land is 2BB, not 2C.
Because land was in the nature of Noy and Julie.
Was.
And yes,
You are
subsequently,
relying upon the ROR only, which cannot be relied upon at this stage.
I cannot. But here, can you see? Their report is adjacent to the PWD road. If it is adjacent to the PWD
It is
road,
not that at all. It is PWD road adjacent to another plot number. Please see the language.
can you see? Plot is adjacent to the Dokkin Sitola Dadul Patra road. Dokkin Sitola Dadul Patra is the high road.
The PWD land in 1850 is adjacent to
Yes.
1848.
Therefore, can you see?
So 1850.
No,
is
I'm
PWD
reading, but
land.
I'm reading full line. Can you see?
Yes.
The concerned government PWD land 1850 and 1848 in plot number such and such, jail number such and such is adjacent to Dokkin Sitola to Dadul Patra road. Meaning thereby, PWD road is Dokkin Sitola to Dadul Patra.
No. PWD road is adjacent to Dokkin Shitola.
No, PWD road is. But then I will bring.
Adjacent to this road.
I will bring this notification that the only the PWD road is Dokkin Sitola to Dadul Patra. I will show that.
Sir, you can bring whatever you like, but no order, no interim order will be passed in this case. And I would request the authority to carry forward. Affidavit of service submitted on behalf of the petitioner and report submitted on behalf of the respondents are taken on record. Paragraph, heard learned counsels for the parties. Paragraph, learned counsel for the petitioner as well as the respondents seek to rely upon other relevant documents in this matter. Paragraph, let the matter appear under the same heading on 23rd February. Next matter.
But 23rd February?
Yes.
That will long delay.
There are a lot of holidays.
So then can you give some protection? Because section 5 notification is not there.
Sir, the
highway authority
will not give you any protection, I assure you. So no protection required.
Highway authority is not notified in the Calcutta Gazette.
Next matter. I understand your concern, sir, for the illegal encroachers, but then the court cannot help.
But if the notification is illegal, lack of jurisdiction, undoubtedly you also have got this power to set aside.
Next.
My lord, petitioner applied for prospecting
before you-
license.
Your lordship will not take up motion anymore.
Mention matters from 12:30. The list.
Only pair 48 to 51, maybe not this week. I may not be here.
Please come back. Let me see. It has not been called. Yes.
My petitioner applied for prospecting license mining lease.
Who is appearing for the
State and the MDTCCL. But my case is this. I am the Rayat. The prospecting license would be granted to the Rayat land. I am the Rayat.
prospective license?
Prospective license on mining lease. Your lordship kindly come to page 13. This is my record of right.
13:13.
113.
Yes.
139, 41, 43. These are my plots. I have applied for these lands, mining lease. This is of 2023. This
Private lands, your own lands.
yes, only.
Private.
Prospecting license is granted over the private land. Next page, your lordship kindly sees the report of the subdivisional officer. After the application, there was a field inquiry. Page 14.
Yes.
This is the report which says 40% area of total area of the proposed sand block is lying within 50 meters distance from the toe of the existing right side of the ex-jomindari embankment. The rule says minimum distance should be 45 meter from the Jamindari embankment. This is 50. I am eligible. The report annexed, this is 15, annexure in the report, which says proposed sand block was visited along with BLRO, right hand column. BLRO, GP member, everyone, and this was found, and drawing was also submitted with the report at page 16. Everything is all right. I applied under RTI Act after the survey also. In December 6, 2023, page 17, wherein it has been replied that these are my plot, classified Danga, Baluchor, and Dou. This is absolutely my land. Now, I have ended up with a copy of a letter by the Mr. Shah's client, your lordship, that is at page 19. This is under challenge before your lordship. Whereas it appears that you have applied for prospecting license cum mining lease for sand river bed material on Nela such and such, measuring about 1 acre 33 hectares, 1.33 hectare, such and such. Whereas it appears from the site inquiry cum verification report of the concerned DLLRO that.
Have you appeared before the authority?
My lord, I could not have.
To this notice?
I could not appear, but final order has already been passed. On the basis of this report of the DLLRO, my lord, surveyed through the BLLRO and the subdivisional officer of the irrigation.
The prayer has been rejected.
Rejected.
So you should have challenged the fact.
That
just indicate one. In terms of this notice, he appeared, he short some time for submission of record of right. Now, on the next date, when the matter was fixed, the petitioner did not turn up. Although request was made for granting extension of time, that was competent authority rejected the time prayer, and ultimately, on the basis of the report submitted by the DLLRO, the application of the petitioner for grant of prospecting license has been cancelled. So she may just hand away the policy. In 2022 November, this Rayati policy was introduced by the government of West Bengal. If you kindly come to serial number 1 and 2, the provision only the Raya owning the land can apply for a mining lease. Admittedly, the petitioner
Is the owner.
is the owner. That is not disputed. If you look at serial number 2, the application, the petitioner or the applicant has to apply in the portal of competent authority, that is Mineral Development. Thereafter, this application will be forwarded by the MDTCL to the district authority. That is serial number 2. The application shall then be evaluated by district land department regarding authenticity of ownership of land and be forwarded with their recommendation. Now, if the recommendation that is not part of the writ petition, may I just hand over the recommendation? It was specifically forwarded or recommended for that this particular land is not fit for grant of prospecting license.
That is that has been stated in page 19 also.
So may I just hand over the recommendation
Yes.
of the district authority? If you also so desire, I can bring in on record by way of affidavit. This is the recommendation. Your lordship kindly come to the next page at the last portion, the final conclusion.
Yes. Why is it not fit? What are the grounds?
It is the on the basis of the recommendation of the DLLR. Because
That is my case.
I have not personally visited the
But
particular site.
my lord, my case is this: DLLRO cannot act without the my lord survey report of the BLLRO and the irrigation department subdivisional officer. He should have acted on the basis of the report filed by the BLLRO and the subdivisional officer. How this DLRO can, my lord, recommend unfit?
Then you say other plots belong to the collector, but where are the documents?
That has not been recorded, but it was recommended by the
Well,
land and land DLLR that although the record has not been corrected, but it should be in the name of the collector.
It's the basics.
And that I cannot justify such recommendation. Mr. Ganguly is there. He is representing.
Nobody can
DLLR.
justify.
You lordship kindly see the very particular thing at page 19 that has not been challenged in the writ petition.
Page 19 has
Page
been
19,
challenged.
P14, whereby his claim has been negated. That is not under challenge. He wants.
That is not, that is after filing of the writ petition.
No. This is part of the writ petition.
This is part, but it has.
Page 19.
Where has not been.
Page 19 directs you to appear before the authority.
Appear.
Yes.
Madam, I challenged this notice because notice is specified that collect, my lord, that the
This has merged with the order.
Yes.
So how can you challenge the notice now?
my lord, I have challenged the order also.
That is in a separate. writ
In a
petition.
separate.
That-
This is appearing also. Page কত? ওটা কত?
Serial number 2.
ওইটা সিরিয়াল নাম্বার কত? এটা W আমাদের কত নম্বর আইটেম? 556.
That is the writ petition number.
Then there
That writ petition needs to be considered, not this.
only this letter is, my lord, approved in order only. Because letter says DLRO's report recommendation. That's
We
true.
cannot pass an order on surmise and conjecture, isn't it? That this has culminated into a final order.
Final order.
So you have to challenge the final order.
Right.
This becomes redundant now.
Right.
My lord, then tomorrow let both the matter be, my lord.
This matter will be disposed of as redundant
Yeah.
because this has culminated into a final order.
Mine.
You
But-
cannot challenge this notice any further. You have to challenge the order.
I have challenged also.
That has been challenged.
I have challenged. I have challenged. It is appearing in the list also. 556.
On the next day, let both the matters appear together.
My lord, tomorrow let
On
it
the
be
next
tomorrow.
day, not tomorrow.
My lord, some urgencies there. My lord, your lordship kindly visualize the situation. Record is in my name. They are saying it is Sikasti without change of record. My lord, they will implicate their name very soon without any process of law.
The other matter is in the mentioned matters list.
No, my lord, 556. The new motion.
Cannot take it up now. Let both the matters appear together.
Incidentally, the writ petition number and serial number is the same. It is serial number 556 and writ petition number is also 556.
556.
My lord, kindly.
Both the matters will appear together. And I would request you to come back with a comprehensive report justifying the grounds taken by you.
Actually, I have acted based upon the policy and on
So the
basis
state
of
has to come back with a
recommendation. So
report.
I-
Very
Come
well.
back with it.
recommendation should be having some basis.
My basic contention was that this basic thing that is before that has not been challenged. Your lordship rightly held. So this petition, whether it should be heard together with the another.
Let both the petitions be taken up together.
Let it.
The notice as well as the.
As the,
subsequent.
after filing of this writ petition, they have issued the final order. Kindly let it be tomorrow.
No, tomorrow I.
Not possible, not possible at all.
Report name. Report name.
The notice issued by the competent authority on 2nd November 2023 is assailed in the writ petition. Stop. It is submitted paragraph, it is submitted on behalf of both the parties that pursuant to the notice, comma, hearing has been held by the competent authority and a final order passed. Stop. The petitioner has assailed the said order in a separate writ petition being WPA
556 of 2024.
556 of 2024. Paragraph in view of the above, let both these matters appear together under the heading action on 1st February.
1st February, then your lordship kindly protect me.
It is your own land. No protection is necessary.
No, because
Not
they
your land.
their contention is this is land of Sikasti, government land. They will try to
You have to show documents.
change the record of right by this time.
That cannot be directed by this court, you are aware? Record of rights.
No, they should not take any further step.
Instead of 1st February, your lordship can extend some more time, you know.
For what?
Because one lawyer is contesting the election.
আপনি থাকবেন দাদা।
Your lordship, that my humble prayer before.
6th February.
Then I do not.
Rajiv, 6th February.
I'm not grateful.
Till such times,
Not necessary. I don't think it is necessary.
Will we come back with the report?
Yes, yes. I'll accept it. Come back. Next.
For the petitioner. আছে কেউ?
Yes.
Stay. No, like I take your lordships to the.
Have you served the authorities?
Yes, I have
the
served
Gram
upon all.
Panchayat, the Jila Parishad.
Everybody I have served, my lord.
Mr. Bandyopadhyay is appearing for the state.
My learned friend probably appearing for the state. Lord, I take your lordships to a drawing
Give me
first.
a minute. Jila Parishad? Yes.
No, I take your losses to a drawing first to understand what's the dispute between the parties. The other really not dispute with the state at least. Well, page 52.
Yes.
Well, kindly take note of plot number 5207. Your lordship is getting it little right hand side.
5207.
Well, this is plot of land of the petitioners. This is, my lord, at least, my lord, 2.64 acre. My lord, I tell you, lordships, there is a warehouse of mine. This is being used by the Food Corporation of India and the Food Supply Department of the state government. My lord, your lordships will find just left hand side of this plot number 6745.
Yes.
My lord, within bracket P, that means it's a private land. Just below that, your lordships will find another box, my lord, and of the 6445. My lord, this plot of land, my lord, it's a my lord, vested land. It's a Khotian number. 6745.
No, the vested land is?
My lord, 674. My lord, it's a total plot, 8 acre of land. Out of that, some portion belongs to private parties, and the rest is lordships a vacant land, government land. Your lordships will find 5207 in between 6745 and 5207, there is a, my lord, a lane or road. In between, there is a place your lordships will find. This is being used as a road to go to the vacant land. My lord, this land I have developed to a certain extent. I have, my lord, planted trees. This has grown up. That's not my point, your lordships. This is for the being used for the public purpose by mine, for parking the car or the lorries, those carrying the materials, because just beside the road, we can't park it up. My lord, we prayed before the government, give it on a rental or on permission on rental basis for long-term basis.
The pathway.
Pathway and the vacant land.
Yes.
So that I can park the car of the FCI departments and food supply department. This is for public purpose.
Which is the vacant land? Both you said P6745P, both the plots.
Both your losses, Malad, just Malad, 6745 is a very big plot.
And the
Just middle portion, that one.
that is also P.
P. Malad, this is also P. Malad, this is
And
your
this
losses.
land B Bonic.
And blend of B Boni. Which one, Malad, then comes? Which one? Malad, just below that. Malad, this portion is also our land. B Boni. And just below that is a government land. So we want this on a long-term basis. Malad, we prayed before the government. Government, your losses will find, directed the, Malad, I just take your losses to page 45. This is our prayer, to the first prayer to the government. Please give it to a long-term lease basis so that we can use it for public purpose. Then government. 56. Then your losses will find at page 56. May I place it all? This is a letter dated 2017. Petition submitted by Sri Sandeep Bonik for grant of long-term settlement of government vested land in plot number such and such. In sending herewith the petition submitted by Sri Sandeep Bonik for grant of long-term settlement of government land in plot number such and such, measuring area 8.84 acres under PS Bhatar, he is requested to inquire the availability of the government vested as prayed for by the appellant and send a detailed report along with sketch map and copies of ROR for further course of action. Well, thereafter, the revenue officer concerned made an inspection. He filed a report according to us. My lord, that there is a report before the government. Now, my lord, we are still using the portion of the land. I'm asking for give me settlement, take money, whatever you charge, so that I can use it for the public purpose also. Well, it will ensure the proper smooth functioning of the warehouse, which is being used by the public authorities for the public purpose. Now, your lordships, though this is pending, Lord, one fine morning on 23rd October, we found that Gram Panchayat, Sahibganj 2 Gram Panchayat, started certain construction work in the middle of it, which, my lord, deter our ingress egress also of the vested land. I'm not, my lord, claiming that this is my land. Now, they cut up all the trees. We made a complaint to the forest department that for, my lord, environment, we have done it because a lot of cars coming there. We have planted those trees for environmental purpose.
Not your land, sir.
No land. But it's for public purpose I have done. It's not my land. I have
any permission.
planting land, your losses, no permission is required unless it is affects someone.
Cannot do that on government land.
Suppose your losses, I have planted certain.
What is your prayer?
Prayer, your losses, my lord. The panchayat is started constructions without any permission. Now, when my application is pending for long-term settlement, my lord, this should not have been done. This is my prayer before your lordships. Because I have not done any illegal things. I have prayed before the government. Allow me.
Government is at liberty to give it to anyone.
Well, I'm not on that. Government is liberty. But there are your losses. Well, there must be some permission to the authorities also.
That is between the government and the panchayat. And
I tell you,
private individual is not supposed to know that.
Since my application is pending, the government could have said, no, I will not give it. Then I could have found it out. I could have.
They have
but
not done that.
Can you insist? All that I'm trying to submit your losses, I am also doing public work by my warehouse. It's for the government purpose. I'm not doing any private work also alone. So, if the land could have been given to me, I could have utilized appropriately. It's a huge land.
Let us hear the state. Yes, Mr. Bandwada.
Well, as my lord, the learned statement was submitted before the Honorable Court, the construction has been made by the Panchayat authority upon the land of the government. That is plot number 6745. Then the Panchayat is the, my lord, the answer.
No, but it is your land and
Then
an
I have to take
application is
instruction,
pending.
my lord, whether the permission has been given to them,
Yes,
whether
now,
they have obtained permission.
first that and then an application by the petitioner is pending before the government. Whether you have considered the application, allowed or rejected.
Then I will come with the report.
Let him come back with a report.
Matlab, do your losses one thing, your losses. I have an alternative prayer also. Matlab, twofold alternative prayer. Matlab, kind have a look. Matlab, planting land, even if your losses look it is not without permission. Even that, matlab, that cannot entitle any authority to cut it off. Matlab, am I clear to your losses?
Again, it is between the panchayat and the
Matlab,
government.
therefore, it requires certain permissions.
The government needs to take steps, not the
That's
private
well,
individual.
that's one of the points. Now your losses kindly see how this was the picture of lot before construction by the Panchayat. I just take your losses to this. But I am also discharging public functions in other way. And kindly will look at this, how the construction in the middle of it. Well, this could have been done in one side of the entire plot of land.
Let the state come back with a report. Because prima facie, you do not have any right.
Well, right, I'm not. But all that right of consideration.
Yes.
Right of consideration.
So let them come back with a report. At this stage, nothing further can be done. Affidavit of service.
But if any further constructions your loss is not carried out,
The government will take steps. Not
no,
the
your
petitioner.
Malad, I'm paying before your lawsuits,
Cannot be. It's between the government and the panchayat. Petitioner has nothing to do.
Malad, on other prayer, Malad, may I make it lawsuits? The other prayer, I have alternative prayer also. Well, this is of course alternative. Whatever they have done, your losses legally or illegally, the rest of the land government can consider to give it on long-term basis.
Well, long-term settlement, my lord, then they will have to go before the tribunal. As it governed by the West Bengal.
No, they consideration.
দাদা, এটা হবে না এখানে এই
No,
কোর্টে
that-
হবে না
Let you come back.
Let him
এই
come back.
কোর্টে হবে সেই জন্য আমিও বলছি না আপনি বললেন বলে বলি
None appears for respondent numbers. You are appearing for the divisional forest officer also?
I think state also.
8, 9, 10 and 11 respite service. Paragraph. It is contended on behalf of the petitioner that the petitioner has been running warehouses for storage of food grains and other material in plot number
Plot number 5207.
5207 owned by him. Stop. A portion of plot number 6745, which is 45, measuring about 8.84 acres, which is vested with the government of West Bengal, is lying vacant and the petitioner intends to utilize the same
And you'll also will find page 56. The district land and land reform officer made an inspection in regard to our prayer also.
You want to utilize the same for the purpose of?
Malad, for the purpose of car parking and others, because all the lorries and malad, huge cars coming for storing the food grains of the government.
For car parking and other purposes. Stop. The petitioner filed an application before the state respondents seeking grant of long-term settlement. Seeking grant of long-term settlement in his favor in respect of the said adjacent land, which is pending. Stop. In the meantime, comma, the Panchayat authorities have started raising construction in the said land without permission of the state authorities, comma, as submitted by learned counsel for the petitioner. Paragraph. Learned counsel for the state respondents seeks to submit a report in the form of affidavit in this regard. Paragraph. Let the matter appear under the same heading on 21st February.
Malad, they have made an inspection. Let them bring it before your lawsuits also at page.
All the relevant documents will be produced. You can take back the photographs. Group one.
Or would your losses keep it first week of February or just prepone this in any point of condition?
12th February.
12 February report আনতে পারবি? বাবা।
Mr. Bandyopadhyay, 12th February.
পারবি না? Well, let us try your losses 12 February. If my learner fin 6 and 5.
Rajiv, 12th February.
চেষ্টা করো।
Yes, next one.
ঠিক আছে, বলে দিচ্ছি চেষ্টা হয়ে গেলে হবে। না, আমি বললাম। সেরকম একটা বছর জানো তো। শুধু শুধু বললো কেটে হবে না।
568. No one.
No one.
None appears for the petitioners. Stop. No accommodation is sought. Paragraph. Let the matter appear under the same heading in the monthly list of February 2024.
569.
Yes, I'm straight response.
Time for the petitioner hearing. So this the petitioner was become a highest bidder, and as per the order, the petitioner could not pay the remaining portion. Therefore, the bid has been cancelled, and the imperial order notice is passed on 26th August.
Prior to that, he has to cross one hurdle because this matter was dismissed on the prayer of the petitioner that he do not want to proceed with the matter.
No.
No liberty was.
I am showing. What happened? What happened?
State respond number 5.
Kindly come to page 44. Before that, one read petition was filed. The read petition was disposed of. That on the same date itself, the order in penalty hearing was served upon the petitioner, and therefore this read petition has been filed challenging the same read petition. Now at this stage, I found that this imperial order is available under Rule 51. So I am praying that the liberty will be given to prefer an appeal before this appeal authority. This is the only prayer I pray.
But prior to that, you lost, you have to recall the order because the matter is as on as dismissed.
No. Dismissed on a different ground or
But the thing is, if he needs any order,
disposal of representation. So by the time the matter was taken up for hearing, representations were already disposed of. So the matter became redundant. That's why it was dismissed. So now he's challenging the order passed in disposing of the representation.
In the
and which is appealable.
Lordship, the thing is the writ petition in which the order has already been, writ petition has been disposed of, in that matter, he is seeking liberty. This is not a fresh writ petition.
Yes, this is a face writ petition.
এটা কত 2022 তো?
No, this is 12,820.
This is a
What's
fresh
happening
writ
here?
এই petition ডিসপোজ হয়ে গেছে।
আরে এটা 2021 এটা 2022 পিটিশন এটা করছে।
Sorry, I stand correct.
Sir, I don't expect it from you.
There he wanted disposal of the representations. Now representation has been decided against him. So he's challenging that order.
Please,
And
please,
he
I
himself says this
want
is an
this
appellate
kind of
order.
court. Please,
অ্যাপ্লিকেশনটা কিসে করেছো?
This is for limitation.
Lordship.
Can করা আছে? So if order, Lordship kindly come page 45 and dated 26 August.
You are asking for liberty to
Lordship.
approach the appellate forum.
Because this the appeal, the order is included is the appealable under Rule 50.
So why did you come before this court?
But this is the only mistake on my part because this is the
It's not a mistake,
Lordship,
sir.
because one that the Lordship early clears the condemnation of delay section. Lordship, there is a
You have come to avoid limitation.
অর্ডারটা কবে গেছিল এটা? ওই 2021
The order passed by the district magistrate Purva Bardhaman on 26th August 2021 is assailed in the writ petition. Paragraph, learned counsel for the petitioner submits that since the said order is amenable to appeal under Rule 51 of the Minor Mineral Concession
Rules
Rules 2016, the petitioner be granted liberty to approach the appellate forum for redressal. Paragraph, in view of the above, the
একটা গন্ডগোল আছে অন্য পিটিশনের সাথে
being WPS such and such is disposed of, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance. Paragraph, in the event the petitioner prefers statutory appeal within
15 days.
sufficient within 1 month.
3 weeks.
Within 1 month from date, the appellate authority shall deal with the appeal on merits without dismissing the same on the ground of limitation. That is the whole purpose of the writ petition. Disposed of, chattel.
Yes. Sorry, I'm straight respond with Mr. Dev.
This one number 2.
Mr. Devroy,
Yes.
where is he?
Well, Mr. Shah is confusing in another matter.
Mail.
570, I beg to appeal for the petition, my lord. The last petition, my lord. I have prayed leave to file a supplementary affidavit because due to our mistake, my lord, the order which has been assailed in the writ petition, the reasoned order which has been passed in pursuant to your lordship direction was not annexed, my lord, by way of supplementary affidavit.
Yeah, people have a decision from some judges. Mine's
This matter relates to a person who was occupying a certain portion of land.
Served all of them.
My lord, there is no private respondents, only states are.
Panchayat Shomiti is there. Have you served the Panchayat?
Minor mineral.
Have you served the Panchayat?
Which stage? Yes.
Yes, it is served.
প্রকৃতি নিয়মে যে মাধ্যমগুলো সমস্ত কিছু
Namkhana Panchayat Shomiti, Shabadi. Where is the service upon the Panchayat?
I have to check the register.
আপনার এটা ইরিগেশন তো এর কিন্তু সেকেন্ড অ্যাপিলেট অথরিটি ডিভিশনাল কমিশন
See, I do not find. Didi, এটা দিন।
যেই না যেগুলো মহাপত্র
Respondent number 9.
যদি এসডিও তে অর্ডার দেয়, ফার্স্ট অ্যাপিল হচ্ছে ডিএম, সেকেন্ড অ্যাপিল ডিভিশন অর্ডার দেয়। যদি ডিএম অর্ডার সেটি হচ্ছে ডিভিশন অর্ডার। এগুলো তো ঠিক আছে। এমন করতে 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 পিটিশনের পয়সা সেভ হয়ে যাবে, এগুলো মক্কেল ঠিক করে গেছে।
Page 10. Petitioner was occupying a portion of land. Some portion is being occupied PWD land, and adjacent to PWD land, he was the owner in respect of, he's a riot in respect of certain lands. Those lands were being acquired and utilized for twofold. PWD land, there was a scheme of rehabilitation. The persons who were occupying PWD lands, there was a scheme to rehabilitate them by paying some money, and also because that was their livelihood, they were running their shops and businesses there. And adjacent to that PWD land, he had certain own land which has been occupied, measuring about 3 decimals. In terms of the scheme, certain amount was paid. There was a scheme, person who was occupying, a committee was formed, committee formulated, the person who is occupying in whatever portion is occupying, and certain amount of compensation for their rehabilitation were made. Initially, for my Rayati land, I did not receive any notice of acquisition. But what I find, in course of construction of the highway, my land has been utilized. And as because there were no notice, I raised objection. Then there were certain commotions. I have been paid a certain amount. Without any notice, I have been paid certain amount, 1 lakh and odd, with the representation by the authorities that the amount of compensation which are to be paid, that would be decided later. These twofold part compensations were paid. Thereafter, my prayer for the full and final compensation was not been heeded upon. We moved this honorable court. Initially, there was an order passed by this honorable court for consideration of my representation. Initially, the representation was dismissed, rejected on the ground that as because there was an order passed by coordinate bills, that as because the persons who were occupying PWD lands, they don't have any right. Therefore, that application was dismissed, which was carried in appeal. Appellate court found no, as because there was a scheme and certain amounts were paid, they were to be paid that amount. Thereafter, again, we came before this honorable court. Your lordship directed the authorities to consider my representation. That representation is the subject matter before your lordship, which I have annexed with the supplementary affidavit. Well, that was, my lord, pleaded in the petition, but due to inadvertence, my lord, the copy was not annexed, my lord. May I place it, my lord?
You have challenged this order in the petition.
We have challenged this order. They say that they did not go into the crux of the matter. They said, I am not the authority. You have to approach the authorities in a strange manner. Let this matter, lands were acquired in pursuant to National Highways Act. And the collector, who's the land acquisition collector, he was nominated, he was appointed as the competent authority by way of a same person who deals with land acquisition and also deals with National Highway. And now the authority says, I have to approach another forum. They are not, may I just place the order which is been assembled before your lordship. Order number 2, I'm skipping the first few lines. Mr. Shamul Larned advocate described twofold grievances on behalf of his petitioner in his submission, as was also stated in the representation, which is the matter for reconsideration in these proceedings. Firstly, he said that his petitioner was enjoying a certain portion of PWD land on the Narayanpur side of Hatania Duvania River, from which he was evicted upon notice served upon him by the National Highway Authority for construction of high-level bridge at Hatania Duvania River, and for which only rupees 31,000 an odd was paid to him. Now, while procuring information through Right to Information Act from the Block Development Office of Namkhana, he found that a sum of rupees 90,000 and odd was sanctioned for him, which was not paid to him by the authority. In the second submission, Sri Shamul Learned Advocate stated that his petitioner was the owner of LR plot number 604 of Mauja Narayanpur, jail number 47 of Police Station Kagdip, South 24 Parganas, which was also taken away by the authority, though neither clearly mentioning regarding the authority who has taken possession nor produced any documents in that regard, to be used for construction of high-level bridge at Hatania Doania River as alleged, and was paid rupees 1,02,945 towards that land. Now, Sri Shamul Learned Advocate paid for the residual due amount towards compensation against eviction from PWD land and to pay compensation as per the Right to Fair Compensation and Transparency in Land Acquisition, Relief, Rehabilitation and Resettlement Act of 2013 for his private land. The submissions made by Sri Shamul Learned Advocate was hard at length, and the matter was explained to him part by part. In regard to his first part of submission, it was admitted by him that the notice for eviction of the government PWD land, which was served upon his client in the year 2014, was a notification issued by the Executive Engineer, National Highway Division, PW Roads Directorate, by memo number such and such under subsection 1 of 24 Control of National Highways Act for removal of unauthorized semi-paka structure within right way of such and such of National Highway 117 regarding unauthorized occupation of public property. It was also admitted by Sri Shamul Learned Advocate that this eviction was in no way related to any land acquisition proceeding initiated by the National Highway Authority, and there was no provision for payment of compensation towards eviction from government land, and on the contrary, there is provisions in the said act to recover the cost of removal of structures and objects over such government land from the authorized occupier, if any. Sri Shamul Learned Advocate also admitted that district administration took steps to provide cost of the damaged structure considering the natural justice to the encroachers whose livelihood, way of earning were affected. Later, a memorandum such and such was issued wherein a committee has been constituted comprising representative of subdivisional office Kagdip, Shabapati Namkhana Panchayat, such and such certain officers or his representative not below the rank of assistant engineer and one representative of each Bapshai Shomitis. The said committee was empowered to take the whole responsibility, right from identification, measurement, assessment up to disbursement of damage, compensation for eviction. In this regard, it is also to be stated here that the writ petitioner, without knocking before the said committee, at that material point of time about his claims, started ventilating his grievances only on and from 16th March 2020 by submitting applications to different government offices upon procuring an information procured in the year 2019 through Right to Information Act 2005 from the Office of the Block Development Officer, Namkhana, after a belated stage of 5 years from the incidents. It is to be mentioned here that the copy of the tabulation sheet as annexed by the petitioner in his writ petition has no signature and seal of the authorized signatory of the committee members, and its authenticity is highly doubtful. Mr. Sri Shamul, the Learned Advocate, admitted the above fact. Sri Shamul, the Learned Advocate, also could not produce any documents which his client submitted before the said committee or before any member of such committee in support of his claim at that period of time. He also admitted that he is not in a position to produce any such document in this regard, even if further time is allowed to him. It was also explained to Mr. Shamul, the Learned Advocate, that the Special Land Acquisition Officer, South 24 Parganas, was not a member of the committee which was formed to deal with the matter for compensation for damages of structure towards eviction from government land, and he is not empowered to redress the grievances of his client regarding unpaid amount of compensation as alleged. Now, as regards the second part of his argument relating to the private land of Sri Mahadev Shah, the writ petitioner, being LR plot number 604 such and such, District South 21, it was pointed out to learned advocate Sri Shamul that his client is not the sole owner of 0.03 acre of suit plot number. On the contrary, the area of plot number such and such is 0.03 acre and his client Sri Mahadev Shah is the owner of only 242 share out of total 10,000 shares. It is evident from the LR record of rights of Mauja such and such, District South 24 Parganas. During hearing, it is explained to learned advocate Sri Shamul that plot number 604 was never acquired through any land acquisition proceeding initiated from the Land Acquisition Authority. Sri Shamul, the learned advocate, stated that the possession over the said plot of land was taken from his ear in the year 2015, and he admitted that this matter is neither related to any acquisition proceeding nor related to the eviction from the government land which happened in 2014. Sri Shamul, the learned advocate, also stated that his client was paid rupees 1,02,945 in the year 2015. This fact was also mentioned in the representation submitted by his client. Sri Shamul is, however, not clear by which authority his client's land was taken away, but stated that money was transferred to his client's bank's account by the block development officer, Namkhana, in the year 2015 towards this land, and as such, he now demands the higher value for taking over the said land. Sri Shamul, the learned advocate, fails to provide a satisfactory explanation to the question relating to the delayed objection grievances raised by his client in the year 2020 after a lapse of about 5 years from the date of receipt of payment, that is 2015, and the latches of his client shown during the period. He stated that his client made several petitions before the authorities stating his grievances, but all failed. When asked to produce copies of such documents placed before the authority, Sri Shamul, learned advocate, prayed for time to produce copies of such documents. Considering the situation, time has been given, my lord. May we come next?
Shall we?
It will continue for some time because there are contradictions.
Factual aspects are also there, so please come. Period of service. None appears for the ninth respondent despite service. Paragraph supplementary affidavit submitted on behalf of the petitioner is taken on record. Paragraph heard learned counsel for the petitioner. Paragraph let the matter appear under the same heading for further consideration on 13th February.
This matter, Mr. Devrai,
627. 627, I appear on behalf of the state, my lord. There is a
Yes.
direction to file report. May I file the report, my lord?
Have you served a copy?
Yes, not yet, sir. I have. You are appearing for the petition. I am handing up the.
A day is gone. We waste a day, isn't it?
This is that matter where, my lord, your lordship, the grant has been made, my lord, in spite of, my lord, directions that what has to be considered. Without considering all these aspects, my lord, in a notified, so the permit has, sorry, the offer letter has been allowed to grant, my lord. Your lordships asked the, there are the relates to, my lord, since long this matter is appearing.
Yes, it's pending for a very long time.
If my learned friend wants.
File a report on the next day. Or today you're filing.
Report has.
Do you want to use an exception to this?
Required.
Report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph, learned counsel for the petitioner seeks to use an exception to the report. Paragraph, let the matter appear under the same heading on 13th February.
13. Grateful. कागज दिन ना
Yes.
Today he came in the court. He appeared on first picture.
Oh.
Monday. Sir, Monday.
No, Friday.
Only
one.
Yes, you are the petitioner.
Yes, my lord, I am petitioner. My lord, Mr. Sudipta Pandar, my lord, also appearing in this, my lord, matter for petitioner. My lord, he for his relative ceremony, my lord, out of sir, my lord.
Let there be a date.
My lord, kindly fix a Monday, my lord.
No, I cannot fix a date like that, sir. Let me see.
Or next week, my lord.
Yes.
Next week, my lord, not this
30th
week.
January.
13th January.
30. On prayer of both the parties, the matter is adjourned. Paragraph, let the matter appear under the same heading on 30th January. Next. No,
I make to appear for petition.
Mr. Devrai is appearing on behalf of the state.
My lord, I am bringing some accommodation because of the reason, my lord. The dash between one route, between the two auto driver groups in a single route. Some negotiation is going on, my lord. That is why, my lord, kindly.
It's going on. So let's wait a long date. Shall I record your submission? I'll just adjourn the matter. On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the order. Prayer of the petitioner.
Some long accommodation, ma'am.
Yes.
Some long accommodation in the month of February.
28th February.
Duplicate.
Let the matter appear under the same heading on 28th February 2024.
Duplicate.
Next.
Well, I have the petition.
Mr. Devrai is appearing on behalf of the state. So it will make it not today.
This is the respondent.
Yes.
This is the main respondent. As per your lordship direction, I have prepared the report. I have served long back. My lord, we have tallied the tender that has already been cancelled by the state respondent for such reason probably.
During pendency of the writ petition, my lord.
So nothing further.
No embargo is there, my lord. Only one thing, my lord, I'm praying people, lordship, my lord. The successful bidder's credentials should not be taken into consideration in further tender, my lord. Only that, my lord, kindly be recorded.
That cannot be.
Because, my lord, because it is the fault on the part of the authority, my lord. The tender has been cancelled, my lord. After filing of the instant writ petition, my lord, they have withdrawn the tender, my lord.
I have mentioned.
Only the credentials, my lord.
I have mentioned in my report, it is the second call. Only one tenderer was eligible. For such reason, we have sent all the papers to the state government because it is the second call. For such reason, they have stated that since there is only one person is eligible, kindly it is cancelled and kindly make it the third call. You are it is mentioned the tender condition maybe more reason for the third call. For such reason, we have made it is cancelled.
Well,
They have mentioned that
Cancelled.
It is cancelled, my lord. Only, my lord, I am paying before your lordship, my lord. The credentials of the successful bidder in the instant tender, my lord, should not be taken into consideration for other tender. Because, my lord, it is the fault on the part of the state, my lord. After filing of the writ petition, my lord, when, my lord, I make a grievance before.
Taken into consideration in a fresh tender. Cannot be. Report in the form of affidavit submitted on behalf of the second respondent is taken on record. Paragraph. The tender dated April 28, 2023 is under challenge in the writ petition. Paragraph. It is not in dispute that during pendency of the writ petition, the said tender has been cancelled by the authority. Paragraph. In view of the above, nothing further nothing further remains to be adjudicated in the writ petition. The same is accordingly disposed of. Urgent certified website. Next.
Very sorry to say one thing, my lord, that there was an
report.
Yes, but you filed a report. The matter relates to, my lord, certain policy matter with regard to, my lord, the auto rickshaw. Now, my lord, now the respondent, my lord, the Barasat RTA, my lord, they sought certain, my lord, I think documents with regard to this policy, 2018 policy and then 2023 policy of the transport department. Now, my lord, only, my lord, my lord, 3 or 4 days back, they received all this. Only I pray, my lord, that another 10 or 12 days, Lord, kindly give me so that I can file the report annexing all those documents.
My lord, I have no objection, but I have challenged the notification issued by the government that is dated 2nd of August 2004. My lord, page 41. That was issued in terms of the order of the Honorable Division Bench. My lord, by that order, it was clearly, my lord, kindly last line, page 41, if your lord say kindly see. No new permit shall be issued for auto rickshaw operating within Kolkata metropolitan area. My lord, this is the order passed by the, this has been issued by the order of the division bench. Therefore, this cannot be altered unless the division bench order is modified or higher court or altered by the authority. That is my question, my lord.
Let Mr. Singh.
Yes, Your Honor, I have no objection. I have stated. I am enlightening my learned friend to take note of that.
Counsel for the respondents seeks further extension of time to submit the report in the form of affidavit as sought. Paragraph. Let the matter appear under the same heading on 1st February. Oh no, it's a Thursday. 2nd February.
My lord. Okay.
My application. So Debra is appearing on behalf of the state respondent.
Only here, my lord, only thing remains, my lord, a report has to be filed, my lord, that has to.
A report was called.
Yes. So, as Mr. Devra is not here, my lord.
I cannot. The matter is adjourned on the ground of learned counsel for the respondents. Petitioner name. Paragraph. Let the matter appear under the same heading on 31st January.
My lord, after that, my lord, because I will not be here, my lord.
My personal difficulties there.
6th February.
But I am.
Mr. Tebra is appearing.
Mr.
How
Debra.
did they make it consider?
Debra is not there. All the matters collapse actually.
All the matters in the court has also been collapsed. My lord, this
31st
is,
January.
this is with regard to tax exemption, my lord.
31st
I am
January.
covered by your lordship's order, wherein, my lord, Mr. Debra is also appearing.
Come back on 31st January.
30th, my lord.
On, huh?
30th.
30th, very well. 30th January. Same order.
Well, Mr. Debra is appearing.
Same order. 31st January. Please come back on 31st January.
Kindly bear me only one thing. Kindly keep your lordship's last order. There was a direction to serve the private effort.
Yes.
But
Okay, so no problem.
in the meeting, my report may be called for. Because my lord, we are marginal because of the society, we are authorized. 635 to illegal running line of in our group. We are just hand to mouth. Kindly call on. That's why humble. We are kindly call.
The matter is adjourned on the ground of learned counsel for the state respondents. Paragraph, let the matter appear under the same heading on 31st January 2024. Paragraph, the state respondents are directed to submit a report in the form of affidavit, comma, if required, comma, in this matter.
I shall
Yes, please communicate.
If required, I shall file my exception. That liberty, my lord.
Let us see if the report comes. A copy of this order. Copy of this order be communicated to learned counsel for the state respondents by the petitioner.
Hello, can it be fixed on 30th, 30?
Very well, 30th.
Evening.
Tirish code. Next.
35, my lord, I am for the petitioner, my lord. My lord, this is a simple consideration. There is a clash of timetable.
Mr. Debra.
My lord, he is the private respondent also there, my lord.
Mr. Debra, please come. Matters are being adjourned on his behalf.
Right.
The matter is adjourned on the ground of learned counsel for the respondents. 24th.
My lord, I have personal difficulty, my lord, 24th. 31st, my lord, 31st.
31st, wait. Since you said consideration, I wanted to make it shorted. Very well, 31st. Let the matter appear under the same
On
heading
24th, I have some medical emergency of my mother.
Okay, no.
Deep level.
Next.
For 6:30, I am appearing on behalf of the petitioner. For extreme urgency, kindly make it known.
No,
Urgency.
no exceptions.
No exception. Follow 24th. 24th. I agree. I agree.
The matter is adjourned on the ground of learned counsel for the respondents.
36.
Huh? Let the matter appear under the same heading on 24th January. Next.
Mr. Debra appearing on the
I am appearing for the petitioner. My lord. This is a case for non-issuing the permit of the modification route after being deposited the requisite fees, my lord, as per leave granted by the honorable.
29th January.
29th.
Bashu, same order, 29th January. On the ground of learned counsel.
Well, this 38 was a very short matter. Well, it may be fixed on 24th.
24th? Very good.
24th.
Bashu, 24th January, on the ground of learned counsel for the respondents.
24. 24.
Well, I am appearing on behalf of the petitioner.
Mr. Debra.
All of my factory is closed. But make it up today only. Only exceptional in this case.
Matter may be disposed of also. My lord, Mr. Debra is appearing, but I am for the private respondent. This is all my lord, in respect of that e-rickshaws.
E-rickshaw matter.
Your lordship,
Same
common
matter,
order
I
is
have
there.
got the judgment.
Mr. Devra,
January,
22nd January.
earlier date.
Yes, ma'am. Review.
Bashu,
Actually, no,
same on
640.
22nd, on the ground of learned counsel for the respondents.
640 টাও আছে তো তাই তো?
640 same, madam. E-weeks, madam.
Same
22nd.
on 22nd January, same. E-rickshaw matters are still there.
All are pending long, total amount of 600, 340 manufacturer and dealer. So only 100 cases.
My lord, in item number 641, I am appearing for the petitioner, my lord. I have served already.
Mr. Devra is appearing on behalf of the state.
He was unwell and he has left court, I believe. So let there be a date.
Let my lord, the affidavit of service be kept with the record.
Bashu, affidavit of service. The matter is adjourned on the ground of learned counsel for the respondents. 30th January, 30.
30th January, as well.
Let the matter appear under the same heading on 30th January, 30.
Regular অসুস্থ হয়ে গেছে নাকি? 30th January, 30th. 30th. 30. Sure.
Mr. Devra appearing on behalf of the state.
My lord, 642, I am for the petitioner, my lord. My lord, the
30th January.
my lord, 24th, my lord.
Going for a lot of matters. 30th. 30th. Huh, please.
That is so call
ওই তো আপনি আছেন। This is my affidavit of service. My lord, I have served all. Railways state is not involved here, my lord. It's only the
You're appearing for the Union of India? Very well.
my lord. The gist fact of the case, my lord. May I narrate in a very nutshell? Petitioner is has a registration with the Indian Railways. On the basis of the registration, my lord, petitioner took part in one e-auction. E-auction was held in respect of conferment of leasement right in respect of front SLR of that particular train. Now, my lord, petitioner has all the essential criteria and credentials. The system is this, practice is this, as per the policy, that at the time of taking part in the auction, I have to submit two documents. One is the annual balance sheet of the previous years and also the profit and loss account. Two columns I have to fill up. If I do not fill up any one of those, then the system will not allow me to go to the next page to submit my bid. Now, my lord, my instruction from my client is this, that petitioner has fulfilled all the criteria and filled up both the columns. Now, my lord, I was allowed to take part in the bid. I submitted my bid. The bid which was generated electronically, it showed that I am the highest bidder. Now, my lord, I was expecting that there will be an agreement with me and the railways. I have deposited my security deposit also prior to taking part in the bid. A month later, my lord, a notice was served upon me saying that as because out of these two columns, I have not filled up the profit and loss accounts column, it's a negligence on my part, negligence as per the railways contention. So they have disqualified my bid and forfeited my security deposits. Now, my lord, I will take your lordship to those paragraphs which have been highlighted by the railways while disqualifying the bid, which is at page 27 of the writ application. Now, see, this is page 27. This is 6th of September 2023. Now, my lord, I am reading. During participation in the aforesaid e-auction, you have mentioned annual turnover of your company amounting to rupees 64,32,000, but you did not upload any document in support for the above claim. In the subject e-auction, the eligibility criteria has been mentioned specifically in para 2.2 of standard conditions of contract as under.
The entity, Lordship, this is the clause. The entity shall be required to upload audited balance sheet and P&L account, that is profit and loss account of the previous financial year in the profile in IREPS before start of auction in which they desire to participate. Railway reserve the right to verify the balance sheet and P&L account uploaded in IREPS profile of the successful bidders at any time during the currency of the contract. And if any information about the annual turnover is found to be false, misleading, or the documents uploaded by the firm are found to be false, invalid, then the railway may take appropriate punitive action against the entity, including but not limited to termination of the awarded stroke running contracts, along with forfeiture of the security deposit or cancellation of allotted lots with forfeiture of earnest money without any further notice. In compliance to the above provision, the participating entity is required to upload P&L account statement in support of their annual business turnover positively. But you have failed to upload a valid document, that is P&L account, which tantamounts to negligence in the bidding procedure. As the only eligibility criteria is not supported by proper document, the competent railway authority, finding no other option, has decided to cancel your bid in the e-auction and to forfeit the amount of earnest money in terms of para 2.2 of standard conditions of contract. Madam, this is the clause which they have shown. From the said clause, it appears that if I upload any document which is false, invalid, or misleading documents, railway reserves the right to verify, scrutinize all those documents, even if I be declared as the highest bidder or I operate the parcel space.
During the contract.
During the contract. Now, my lord, kindly come to the rules, which is at page 30.
Yes.
My lord, rules which is 2.2, which has been shown, it has been reiterated in this similar way at clause 1.2.
1.2.
1.2, my lord, FM circular. Now, the entity shall be required to upload the audited balance sheets and PL account statements of the last 3 financial years in their profile in IRPS before start of bidding in the auction in which they want to participate. Railway shall verify the audited balance sheet and PL account statement uploaded. Same terms. Now, my lord, kindly come to clause 1.4. This is very vital and relevant. If the turnover details, same page, if the turnover details are not entered by a registered entity in its IREPS profile, the system will not allow the entity to participate in auctions for lots for which the minimum turnover required is greater than 0. So any auction is greater than 0, the commercial price. So if I do not upload any document, then the system will not allow even to quote my bid. Now, my lord, punitive measures have been exercised upon me that I was negligent in not uploading one of the documents. My contention is this, my lord. Railway can only exercise or can impose punitive measures if I have submitted false, invalid, or misleading documents.
1.2.
1.2. So they're clear in their contention. Nowhere they can punish me or lordship by forfeiting the security deposits if I fail to upload any document. Lordship, for this, clause 1.4 clearly says that if I do not fill up any of the columns in support of the documents which is stated here, I will not be allowed to participate in the bid, or I will not be allowed to register my bid. Now, my lord, kindly come to the bid. That is 26A. Lordship, this is the typed copy of the bid. I have annexed the bid which was generated from page 26, and this is a typed copy. My lord, kindly see the auction date, that is of 17th of August 2023. Then, lordship, kindly come to the highest bidder details, Mrs. Anjali Shivam Cargo Howrah. The bid which I have quoted, that is 42,561. So this is the contract value, and lordship, this is the EMD which I have deposited. Now, my lord, audited balance sheets I have annexed here, which is appearing at page 66. Now, my lord, my contention is this: if I have not filled up the column, this wouldn't have been generated even. So the allegation against me from the railway side is not that I have defrauded the railways, or I have made it some misdeclaration, or I have made it some false documents. This is not the allegation. Allegation is that I have not uploaded, I was negligent. Now, my lord, kindly come to my annual turnover details, which is at page 70, page 66.
Yes.
Actually, this is the documents which I have uploaded. As you kindly see, this is audited report 68. And page 70 is the annual turnover, page 70. 64,32,450. Page 70. This is the profit and loss account, which is 64 lakhs. And my respectful submission is this, my lord. On the basis of these documents, I am a proprietorship concern. I am operating on the basis of these documents, and I have been awarded contract by the railways in 2 different trains, which at present I am running. It will appear from page 73.
This is for the year ended 31st March 2021.
21. Any of the preceding years, that is there at page 1.2. I am showing, my lord. Lordship has asked me this question. Yes, page 1.3. Lordship, can you come to page 30? 1.3. Lordship has found, my lord?
Yes.
If the audited balance sheet and or PL account statement of all of the 3 preceding years are not available, then the documents of the years for which the same are available shall be uploaded, and same will be taken into consideration for judging the eligibility of the bidder. So my respectful submission is this, my lord. I have not defrauded the railways. I have not filled up with any any documents which is misleading or invalid. Even if I say, my lord, the allegation is true, then in that case, clause 1.4 debars me to register my bid. And that also, my lord, the railways could have at least taken me into consideration and could have at least give me a notice saying that this document is missing. You kindly come and provide me with these documents. Now, on the strength of negligent act and the point which they have taken, my lord, they are not empowered to impose punitive measures upon me, and that too, at least without giving me an opportunity to have a hearing. At least I should have been given an opportunity of hearing to the railways. The same railways is giving me the 2 tenders on the basis of these documents. So the allegation of the railway is not that I have submitted false documents, as appears from the disqualification notice, my lord.
Let us hear the railways.
Is 30 below 1 point clearly stated the entity shall be required to upload the audited balance sheet and profit and loss account statement of the last financial year in their profile in either request before start of the bidding in the option in which they 1%. Railway shall verify the audited balance sheet and statement uploaded in the profile in either case of the successful contractor. Anything after acceptance of the bid or during the currency of the contract, and if the information about the executive is found to be false, misleading, or document, or the documents uploaded by the firm are found to be false invalid, then the allotment of lots shall be cancelled, or if the contract has been issued, the same shall be terminated for breaching the security duties without any contribution. Not in this case, not. They have not uploaded the provision loss account and balance sheet below.
So it is not covered under 1.2?
It is 1.2 where it should be uploaded the balance sheet and account.
Please come to 1.4.
You should kindly see the 1.3 first below. If the audited balance sheet and profit and loss account of all the 3 preceding years are not available, then the documents of the year out of the 3 preceding years for which the same are available shall be uploaded, And same will be taken into consideration for judging the validity of the bidder. Then we are 1.4. If the turnover details are not entered by a registered entity in IRDS profile, the system will not allow the entity to participate in auction for lot for which the minimum turnover required is greater than 0. So, my lord, they have not uploaded the profit and loss account and balance sheet, my lord. It is a
So where is the provision for imposition of penalty or cancellation for not uploading?
then lots of
Grateful,
kindly say,
Admittedly, they have participated, isn't it?
Not great.
my lord, 1.2 that is clearly stated that if they have not uploaded the balance
No, it is not stated, sir. I'm
I
sorry.
have to kindly see it, my lord. If the information about the financial entity is found to be false, misleading or
Yes.
documents uploaded by the firm are found to be false.
So this is after uploading.
Not an upload.
If it is uploaded and it is found to be false or misleading, this provision applies.
Then that if it is not uploaded, but they are not entitled.
1.4, if it is not uploaded, they cannot participate at all. Since they have admittedly participated, it can be inferred that they have uploaded.
And my lord,
1.4.
yes, 1.4, if the turnover details are not entered by registered entry, the system will not allow the entity to participate.
Yes. So since the system has allowed them to participate, we can infer that they have uploaded. And it is not your case that the documents are false or invalid or misleading. So where is the provision?
Page 36, my lord.
Yes, page 36. Yes.
19.2, lordship. If the contractor fails to pay the full due amount as
Is that your case?
page 36.
Is that your case?
No, that is not my case.
Then do you have any further submission to make? Where is the document showing you as the highest bidder?
Yes. That is at page 26. Typed copy is at page 26A. This has been generated from the system.
Right.
It is, my bid is also there, 42,561.
Yes, yes, I've seen this.
This bid is also there.
Yes, sir. Anything further to submit?
My lord,
And only my prayer is, my lord, for refund of.
then lordship, I will file everything.
Affidavit. Why?
But what is the
Everything is clear on the face of the record.
No, my lord,
What further? How can you improve your case? By an affidavit?
No, I want to file a affidavit, not whether why they should kept cancel the security deposit, my lord. So we are not file alone very short period. my lord.
Please come back with a report in the form of an affidavit. A affidavit is not required.
In the meantime, staying of this operation, disqualification of the bid. But there is no provision at all, my lord. At least they could have called me, I would have submitted once again. By negligent act, they will Lordship, deduct my security deposit, forfeit it, my lord. I'm putting this question to myself.
Affidavit of service. It is contended on behalf of the petitioner that the petitioner participated in an e-auction floated by the railway authorities The auction was for
Auction was for conferment of leasement right, my lord. I have annexed at page 24. In respect of column 3, 13021, page 24, last column. This is the auction.
for parcel space in SLR coach in a particular train and being declared as highest bidder therein, comma, deposited earnest money to the tune of rupees 7,76,738 with the railways, along with other requisite formalities. Stop. The assistant commercial manager, comma, slash HC, comma, for senior divisional commercial manager, comma, Howrah, comma, by a letter issued on 6th September 2023, comma, informed the petitioner that since the petitioner did not upload any document in support of his claim and therefore did not fulfill the eligibility criteria for the tender, comma, the bid of the petitioner was cancelled and the earnest money forfeited. Paragraph. Learned Counsel has taken this court to clause 1.2 of the Freight Marketing Circular number 11 of 2022, which empowers the authority to cancel the allotment, terminate the allotment / contract if the information furnished by the petitioner is found to be false, comma, misleading, or the documents uploaded are found to be false or invalid. Clause 1.4 demonstrates that if the turnover details are not entered by a registered entity in its IREPS profile, comma, the system will not allow the entity to participate in auctions for lots, LOTS, for which the minimum turnover required is greater than 0. Page 30 te paben ei dutoi clause. ZDR, ZDR. Paragraph. Learned Counsel for the respondents seeks to submit a report in the form of affidavit in this regard. Paragraph. Let the matter appear under the same heading on 29th January.
It's a very short issue, my lord.
That's right.
In the
I
meantime,
was intending to dispose it of today itself, but
no, Lordship, it could have
Counsel
been,
was
my
to come
lord.
back with a report. Let him
It demonstrates high-handedness, my lord.
29th.
Lordship, stay in the meantime disqualification. The notice.
The letter impugned dated such and such. Impugned.
Page 27.
যেটা বললাম একটু আগে।
6th of September 2023.
He stayed in the meantime.
Grateful, my lord.
He stayed until further orders. He stayed until further orders.
On 29th, my lord.
29th.
Let them serve an advance copy if that, so that I can at least use an exception on that day itself.
Use your oral exception.
কি করব?
Next matter.
হ্যাঁ করে দিচ্ছি। Grateful, man. Highly grateful. এই যে আমি করে দিচ্ছি এই নাম্বার। হ্যাঁ নাম্বারটা দিন।
I am for the petition one.
Have you served the
Yes.
opposite party?
Yes. This is the express. It is express. Affidavit of service, personal notice I have served. I prayed for extension of interval dated 3rd August 2023 because main content.
This is the service. This is the service.
And copy of this application for extension has also been served upon the learned advocate. I have handed over before lordships the copy of this application.
None appears for the opposite parties despite service. Paragraph, the order of stay granted earlier is extended till 29th February 2024 or until further orders, comma, whichever is earlier. Paragraph, the matter be placed before the regular bench.
Deeply applied.
This is my application, my lord. Sir, my affidavit of service, my further notice that the matter will be taken up today.
You are appearing for the opposite parties.
The short point is this, whether the petitioner can be added as a party in the suit. Now, the background is this, my lord. The petitioner made a complaint to the Panihati municipality for illegal construction. And at page 20, Lordship will find Justice Sampar Sarkar has directed for inquiry. If it is found, then it should be demolished according to law.
You are appearing for all the respondents.
Opposite party.
Plaintiff opposite party, yes.
Now, after that,
Board of Councillors also.
No.
I have served upon them, my lord. Lordship kindly see the affidavit of service. This notice, today's notice is not served, but earlier copy has been served. Because my learned friend is having caveat.
State.
Today it is mentioned. He's for caveat too.
Yes, but we serve and come back. There's no urgency as such.
But there is urgency in this extent. The miscellaneous appeal will be heard on 22nd,
What is the miscellaneous appeal on?
22 January. I tell you, Lordship, what happened. After the passing of the order of my Lord Justice Sampar Sarkar, municipality proceeded under section 218. Notice has been given to them, both the parties. And they preferred, the municipality has directed to demolish. That is the order dated 20th August. They challenged that order in a municipal appeal. Municipal appeal in the appeal court did not pass an interim order. They preferred a title suit, challenging the same order. Now, in municipal appeal, I am the party. In title suit, I am not the party. When it came to our knowledge, in title suit, the learned court below did not pass an interim order. They preferred miscellaneous appeal. That appeal is fixed on 22nd. When appeal court passed an interim order, we came to know about that. We made an application for addition of party before the trial court as well as before the appeal court. The application before the trial court is pending. The appeal court heard the application and disposed of, rejected it, stating that I am not the necessary party, my right and interest will not be affected if the appeal is heard without me. That is under challenge before lawsuit. Now, my lord, the same order is challenged in municipal appeal, is also in the title suit.
What is the urgency is that it cannot wait for the.
Urgency is this one because the appeal,
Bench to come.
because the appeal is to be heard on 22nd of January. Only this.
It's not an urgency, sir. Please serve in the meantime. Let the matter appear before the regular bench. Please serve the other person.
Then Lordship, kindly give a short period of stay, because if the appeal is heard, now what happened, my Lordship will kindly see, if the appeal is heard, if appeal court says that I am not the necessary party, then what is the use of application before the trial court? That goes infructuous.
Where is the order?
Lordship, last annexure, certified copy. Page 2 of the certified copy, Lordship will see. Have got no connection whatsoever with the present application. Same order is under challenge. Whatever thing has happened till date, it is on my complaint. The municipality has taken step on my complaint. Now I am not a necessary party. And this part makes the application before the trial court infructuous.
Yes.
This is my suit whereby I pray before the full court below, seeking the permanent injunction against the municipalities, not to overact. Now, in that suit, the injunction that was granted, I was being aggrieved by the injunction, the manner it was granted. I went up in Missouri.
Injunction was not granted, I think.
The injunction was not granted, what I had prayed for. I went up in Missouri. Now, in Miss Appeal, they filed an application and me as a party. His application for addition of party is pending in the suit. That is not being allowed. Now, in the Miss Appeal court, the court held.
That is still pending. It's not been disposed of.
Not being disposed of. That's pending. The appeal court held, be that as it may, it's between the plaintiff and the municipality because overaction of the municipality has been alleged in the suit. You are nowhere required. It's the municipality who will take the defense. And there is no allegation whatsoever against the plaintiff, the proposed direct defendant. So in that circumstances, the additional.
He is the landowner.
I'm the landowner.
He might be the landowner, but there is no allegation, a single allegation against the proposed direct defendants.
In the suit.
In the suit.
There is allegation.
The Miss Appeal court says you are not necessary because allegation and the cause of action is against the municipality. So therefore, you are not required, not a necessary party, not even a proper party. Now, court has even more so. When his application for addition of parties pending in the suit, he doesn't proceed with that. He directly jumps to the Miss Appeal court and says, "I'd be as a party."
Same time it is filed.
So therefore,
simultaneously,
application today has to be decided one way or the other, whether he is at all necessary in the suit or not. He cannot jump onto the appeal court and say, "I'd be as a party."
You have made the same application parallelly before two forums.
Because the appeal has come first. Then I am told that if I am not filed before the trial court also, what the appeal court will do? Now, what the order of the appeal court make infructuous the instant application before the trial court. It is kindly see the order. Kindly see the order.
I don't think there is urgency to be dealt with by this court. Please appear before the regular bench. Serve the other respondent.
I will serve it, my lord. My lord, in the meantime, 22nd is the date.
Another day is not wasted.
22nd is the date, my lord.
Yes, 22nd it will not get disposed of, sir.
No, appeal will be heard on 22nd. The non-defendant can confirm it.
Will it be disposed of in a day? You can move before the court and say this court is in session of the matter. When the High Court is in session of a matter, I don't think the district court will touch the
They
matter.
do not give any, because I cannot make any,
That is why
Lordship kindly consider, I cannot make any application because I am not a party in that suit, in that appeal. Court will not consider my any application at all.
When is the date for hearing of your order on Rule 10 before the trial court?
In April. What can be done, my lord? If I am a party, I could make an application under section 10 also.
This is a rejection order, cannot be stayed. A positive order can be stayed, a negative order cannot be stayed. The order is in any event a rejection order.
Rejection order, but it is positive to me because I cannot
stay. It goes against you.
Because I could not participate. I could not participate. I cannot make any application under section 10 also.
Heard on merits. An interim order cannot be passed like this. Affidavit of service. An order passed by the learned additional district and sessions judge, comma, fast track FASD. First court, comma, fast track first court, comma, Barakpur, comma, North 24 Parganas on 11th October 2023 in Miss Appeal 27 of 2023, rejecting the prayer of the petitioner under Order 1, Rule 10 within bracket 2 of the Code of Civil Procedure is assailed in the writ petition. Paragraph, the petition. Huh? Single division. The petitioner is directed to serve copy of the application along with annexure thereto upon the second respondent. The first opposite party is represented. The petitioner is directed to upon the second opposite party and file affidavit of service on the adjourned date. Paragraph, let the matter appear before the matter be placed before the regular bench. Yes, I've recorded that.
I'm grateful to you.
Next.
I am opposing this application.
What is the application of?
Well, dependent is the petitioner in the present judicial act. So let's just look for declaration and permanent injunction. The challenge before Malad is an order whereby Malad takes the impugn order for once. Certified copy.
5th August judgment.
Yes.
Yes.
Now, Malad, here, by virtue of this judgment, Malad, the injunction which has been granted in favor of the defendant has been satisfied by the appeal.
In favor of the defendant.
To some extent, their injunction application has been refused. So, what happened here, the defendant is a tenant is respectable. Now, the top room is measuring about 400 square. 400 square. Now, the defendant's allegation is that 200 square feet has been agreed between the developer and the
landlord.
The defendant. That 200 square feet will be given up by the defendant tenant, and rest will be possessed by him, and against that a consideration was offered. Now, what happened? That should previous to that, when the remaining 200 have been outstayed, I filed the suit in the self-same court, whereby I seek my declaration of my tenancy. Now, and pursuant to that, an injunction was granted in my favor, not to disturb my position.
In respect of the remaining portion.
Yes. Now, suppressing that, where the parties have a caveat to that. He was on caveat, he was served a notice of injunction. Suppressing that order, now the present plaintiffs or the opposite parties hearing institutes a suit, whereby they seek implementation of that clause in the development agreement by virtue of which they can raise multi-story building over the property. Now, to that, in that, an injunction application to that form was created. The trial court refused.
But that is beyond your property.
No, the entire, including mine. They now intend to construct into the entire, including mine. Now, the appeal court reverses it, says they can merely carry on the development construction over the property without protecting my people. I have 2 points to answer. First is, this is the injunction was in an equitable way. Suppresses before the court about the injunction which was granted in the earlier suit where he was a party, and my right was protected. That there was a clear suppression to that. Secondly, at the time of hearing, as he pointed out that 2 or 3 plaintiffs have died in the meantime. The court records that yes, 2 or 3 plaintiffs have expired. Despite that, the court proceeds without carrying on a substitution of the present. Now, passes an order.
Now, we will kindly take, now in this background, we will take some the intro.
And there are other plaintiffs.
Yes, there are.
The matter may have abated against, with regard to those plaintiffs.
Name of those plaintiffs had to be
expunged.
Like dead man will not cannot remain in a. There was nothing, on their base to expunge.
40 লাখ টাকা জমা দিলেন তাহলে তো ছেড়ে হয়ে যাবে
No, I mean only to that extent.
40 লাখ টাকা জমা
I will kindly take some decision with reason part. This is a longish order. I will not take my lord to the entire.
At page.
Sorry, sir.
Yes. Page 12, internal page 12.
Internal page 12. Yes, first. Usually,
yes.
Usually, the prayer for a grant of an interlocutory shortfall at a stage with the existence of legal rights asserted by the plaintiff and his alleged violations of contested and uncertain and even uncertainties they are established at a trial on evidence. The court at this stage acts on certain well-settled principles of administration of this form of interlocutory, which is both temporary and discretionary. The object of the interlocutory injunction is stated is to be protect the plaintiff against the injury by violation of his rights for which he could not be adequately be compensated with damages recoverable in the action if uncertainties were resolved in the favor at the trial. The need for such protection must be weighed against the corresponding need of the defendant protected against.
These are the principles of law which are
principles of law which has been stated. Now, now from here. Now kindly turns to paragraph 13. Internal page 16.
Yes.
Paragraph 30.
30. Once. Prior to paragraph 13, I just like to point out my indication for the court below about the death of the plaintiffs. Kindly turns to internal page 5. That would be important.
Internal page 5. That's stated in the later part of the order also. But the court says that one of the owners can also file a suit.
Power of attorney holder, my lord, it can continue. That is taken care of.
The names have not been accepted. That's technical. Let's deal with it on
merits. Only two things, kindly turns to internal page 5 of the judge.
Yes.
Paragraph 4, the defense of the defense case. It is the case of the defendant that the suit is not maintainable according to law and the plaintiff number 1, Sri Nandalal Shah, and plaintiff number 6, Sri Sonalal Shah passed away, but they have been shown as the plaintiff in this case. Moreover, the name of the plaintiff number 2, Joylal Shah, has been wrongly written in the place of Jaglal Shah, who also expired. Therefore, according to the defendant, the power of attorney automatically revoked, and the suit becomes liable to be rejected for dishonored and non-joined party. It is further stated in the written statement that the barred by law of the as prior to filing of the present suit, the defendant filed a suit by case number 502/2022 before the learned second court civil judge examination Barakpur over the same holding of the property and the said suit is still pending. It is further added in the content another suit in case number 469 of 2017 filed by side such and such pending before the second court of civil judge Barakpur over the same schedule property. Defendant has stated that thereafter I am not reading the entire. Then will not kindly turn over to you.
পুরোটা পড় না পুরোটা পড় ওই দুই গেল তারপর তো আসল তারপরে তো পড়
not to worry, Mr. Roy, not to worry.
I'm not worrying. I'm just indicating.
Kindly turn to internal page 7.
Yes.
Internal page 7 10 lines bottom after Raila Khatun, it is the claim of the defendant.
Yes.
It is the claim of the defendant that he is a tenant in respect of one shop room measuring 400 square feet in respect of building number such in the name and size of the supply company, and he has been depositing his rent to the responsible at Baratpur in instance. The defendant had denied that he refused to vacate the entire property in favor of the plaintiff in lieu of 37 lakhs, but he admitted that he agreed to develop 200 square feet out of 400 square feet property to the plaintiff. Therefore, alleging that the agreement executed with the defendant for surrender property was false and fabricated. The defendant lodged FIR against the plaintiff number 7. It is denied that any alleged incident on 2012 to 20 occurred, and it is also denied the plaintiff has stated construction was started the construction of location property. The defendant alleged that plaintiff number 7 and his maid and agents had tried to hand over possession of this 200 square feet to another person for his high value infringing the right of the defendant after committing the offence ordinary the breach of trust. Now, we got in this gamut, we got in title suit number, we got 502, which I have pleaded, we got court granted an injunction in favor. Now, we got without taking into consideration this aspects of granting of injunction by the court, we got by same court, we got with respect to the sell property. Now, we got the court passes an order. We got now can it talk about the impugned order, we got the relevant part. Paragraph 30.
The injunction order in your favor was granted by the trial court.
Yes. No, not in this suit, but in 502.
Yes, in the earlier suit where you were the plaintiff.
Well, I was
right. Right.
Now, we not in this background, we not kindly takes up the impugned order, paragraph 13 only.
Paragraph 13, yes.
No, paragraph 14 only. Per contract.
Yes.
Per contract, the learned counsel appearing for the defendant claiming very actively argued that the claim of the plaintiff is not maintainable and some of the claims are already partially, but the legal errors have not been substituted in the suit. In the next fold of this argument, the learned counsel for the defendant contains the plaintiff suppressed in the claim of the suit that in respect of A schedule property, the legal errors of Rahila Khatun filed the suit for declaration of title over the A schedule property by filing case number 469 of 2017. And in that suit, the present defendant was the defendant number 12. And some of the present plaintiffs were also included in that suit as defendant. According to the defendant, said suit is still pending for the learned court to give the investigation as shall, but the plaintiff was present was intentionally omitted to mention about the said suit. The learned counsel for the defendant continued his argument, stating that the present defendant filed a suit against the plaintiff's title suit number 460 of 2017, and in that suit of the defendant, by case number 502 of 22, the present defendant paid for declaration of his tenancy right over 400 square feet of top room over A schedule property. The argument of the defendant is that the plaintiff of the present suit has intentionally suppressed about the state title suit filed by the defendant, and so the prayer for injunction cannot be granted for suppression of material fact. So, this is my sole and bold contention here. Now, in this contention, the court goes on to show records. I am not troubling with the enter, but summing up. The court says, at this prima facie stage that you have not documented to prima facie show that you are entitled to 400 square feet. Therefore, and the rent control receipts which I rely upon are subsequent to the filing of the suit. And then court says, since you have accepted 37 lakhs, which I agree, yes, I have also not denied that. Against that 200 square feet, therefore there is no embargo in raising construction over the entire property. Now, my respect to the humble submission question before the court is today, when I am already enjoying an injunction in another court, they do not take any steps in that suit despite having knowledge of the same. And the court in suppression having known of the fact, knowing the fact, passes an order permitting construction, this is in itself a conflict of decision.
This A schedule property includes your 200 square feet.
200 square feet as well. Because I am not saying the entire construction be stopped for a moment. Let that 200 square feet be protected for the time being. Because I am not claiming whatever area they have. I have a right with respect to 400. Out of 400, 200 is given to them, I admit.
At present, it's only 200.
It's only 200. Because I am being protected in another suit. They are aware of this.
Let us hear Mr. Roy.
Documents to this. যেটা এগ্রিমেন্টের হ্যান্ড ওভার পজিশন Lordship, I can turn to the plaint which is annexed regarding 52 of 2022, 502 of 2022, page 35. I got it.
Yes.
Okay.
36. So, the plaintiff is a tenant in respect of one shop room. My lord, can you consider who are the parties here? Saida Sultana Begum, Said Sohrab Ali, and Said Sikandar Ali. পার্টি হবে না দেখ এই তিনজন কি ইয়েতে পার্টি আছে দেখ এখানে Case 35 is
They are the developers.
Different plaintiff number 7 is the only developer as the landowner's claim. Let another suit by
In
the
your
original.
suit.
No.
In your title suit.
Not in my title suit.
in their title suit, my lord, I am not the party. I am representing the developers. So to what extent I can suppress the fact, my lord, that is something else, my lord. A document was executed. He
You are
put.
representing
I am representing 7.
only 7.
Yes, the developer who is now ultimately, my lord, I am in the receiving end.
Others.
Power of attorney আমাদের
Power of attorney belongs to given to me. এই ডকুমেন্টে চ্যালেঞ্জ নেই ওরা কারণ ওই যে ফাইল করেছিল ওরা কারণ
Yes.
469
এখানে now my lord, can you turn to if your lordship can you consider who are the defendants Saida Sultana Begum, Said Sohrab Ali, and Said Sikandar Ali. Against them, my learned friend filed a suit. Pause here for a moment and can you turn to the present suit, plaintiff of the present suit.
At page
That is at page
17.
big two character once. Present suit plaintiff there.
1242 of 2020.
Yes, ma'am. 17.
Yes.
Can you consider who have filed the suit and against whom?
Yes.
So what he's trying to do now,
They are the owners, the others, the other plaintiffs.
original owner.
they are the original owners. They filed the suit against this person. He himself claiming to be that he is the owner against whom he filed a suit. Merely can file a suit against XYZ, irrespective of fact whether we are the party in that suit. No. American submission, no. Next is, my lord, he now claiming that he is in occupation of 400 square feet. A document is not coming forward with the court below, the showing that he is in existence of 400 square feet. On the contrary, our is that you are supposed to, whatever extent your tenancy has, you are supposed to hand over the same after accessing 37 lakhs.
Entire tenancy.
Yes, enter that document I'll satisfy. We paid 37 lakhs, 200 square feet, 37 lakhs, my lord. The place where it is mentioned, my lord, is quite unnatural. Not only unnatural, it is, if you are logically consider, it is at Barakpur, 200 square feet. He is saying that it is only 200 square feet. The court came to a positive finding, my lord. I am drawing lordship attention so far the finding portion is concerned.
Is there any document of handing over?
Yes, the document was considered. Position letter, this is the money, this is the court. This is the document.
So that is with respect to what there is no dispute to that.
Let me finish. You have said, let me finish.
Stated here in this document?
Yes. And it was considered by the Court of Appeal below.
Only 200.
This is 200 square feet.
Yes.
Not the remaining 200.
Now he is claiming to be in possession of 400 square feet. No, he is claiming 400 square feet, out of which he gave 200 in lieu of 37 lakhs. And he is in possession of rest 200. He gave whatever the tenancy has, that in respect of 200 square feet. The court came to the finding that you are unable to produce any document showing that you are in occupation of 400 square feet. So today, the consider the possession letter.
1 minute. Is there any document to show that he was in possession of 400 square feet?
No, that is the findings of the learned court below.
I have a shop room of book supply. Milord, my book supply shop room was total consisted of Milord 400 square feet.
Documents.
Milord, document to that extent, Milord, rent receipts, Milord, which was deposited, Milord, before the rent control.
After filing of the suit, post-suit document. Post-suit document, that was considered. There is, yes.
Milord, prior to suit, Milord, as such,
Post-suit
no.
document
Milord,
cannot
I
be taken
cannot
into
improve on that
consideration.
today, Milord. I do not have any document to show prior to suit. But today, Milord, if I call upon him to show Milord his sanction plan where they have, where he has earmarked, Milord, my 200 square feet, Milord, let him produce that. Let him produce that. He do not produce that.
That is not necessary at this moment.
Because Milord, he obtains a sanction plan, Milord, with a.
Is there any pleadings?
It is your case. You say that you are occupying 400.
It is, he has to prove.
Over 200. So where is that initial 400?
Yes, I am out of court.
Milord, let that be measured, Milord. It's still there.
Let him file an application over there. He can ask for production of the document. That it is a civil suit.
200 square feet. I'm not stopping the entire. Milord, he cannot develop the entire property overnight. Milord, he cannot. But today,
let there be an interim order with regard to the 200.
Well, can you consider where the 200 is? I put this question to myself. Where is the 200? Malad is passing an order of injunction.
The earlier suit doesn't reflect.
Milord, kindly take
502.
Well, there, Malad, I am not a party. We are not the party. Somebody else was there.
Kindly takes up the order passed in 502, which is at
400 square feet.
This is 400 square
feet. 400.
So,
kindly please.
Document.
What is the 200? Well, I put this also to myself. What is the specification? Malad is an injunction cannot be passed in a vague schedule.
The earlier title suit is on 400 square feet.
Yes, Milord, has to be because I am claiming tenancy of the entire 400. Milord, out of that, I say in this suit also, Milord, 200 has been given to them. Milord, the rest 200, Milord.
Which 200? How do you demarcate? How do you identify?
Milord, can you take up the schedule?
Schedule of?
The 502.
Yes. That is entire 400.
400 square feet.
Covering entire.
And the schedule is and the boundary in respect of the entire property.
Milord, at the ground floor.
400 square feet.
Milord, because this is my claim of tenancy over 400. That's why it's the 400 given.
Any document with regard to the subsequent development. Where is the 200 that you're occupying now?
Milord, it's this 400 which has to be, Milord, out of this 400, 200 has to be kept.
Where is that document showing that you had 400 and you have given out, only 200 was to be given?
Right,
because
this
the
agreement
shows agreement is 200 and
200.
Yes.
Milord, I
200.
And 37 lakhs I have paid?
Yes. Milord, I say.
There is nothing to show that the remaining 200 is in your possession.
Milord, Milord, this 200, Milord, today, Milord, this court, Milord, doesn't consider, Milord, but this 200 is at their hands. Milord, I am not, I mean, out of the possession, they are constructing. Milord, if this goes, Milord, change of entire nature is changed today. Milord, I cannot be able to show this 200 even. Milord, how do I show, Milord, a possession?
Also.
Milord,
today also you're not able to show that.
Milord, exactly, Milord, if somebody is sent from here.
You have to make out a prima facie case, isn't it?
No, Milord, kindly appreciate, Milord. My claim is, Milord, 400 of square feet of terrace. Milord, I admittedly, Milord, say.
Only your claim. I do not find any document to substantiate your claim.
Milord, only document today, Milord, I can show, Milord, is the rate control, Milord, Charan, because no rent receipts were previously given. No rent receipts were previously given. And furthermore, Milord, under the Municipal Corporation Act, Milord, the plan which they obtained is on the basis of the occupation of the tenant. Milord, he said, Milord, I am one of the tenant of having 200 square feet, Milord. In the plan, Milord, let him produce, he shows by 200 square feet. Milord,
if that be so, my lord, if
obtains an extra FAR.
My lord, if that be so, he has ample opportunity to ask for the plan and production of the court below.
Let that be produced, Milord. If today
my lord is exercising power today, I am on the.
If today, Milord, the construction.
Today, my lord, I am.
Any order passed by this court with regard to your 200 square feet will be a futile exercise because how do you identify that part?
Milord, he is well, Milord, highly appreciates. Milord, he takes possession from me. Milord, he knows my area. He is not in dispute that.
Court needs to know. Is that sufficient if he knows?
Bear me for a moment. Milord, today, Milord, I was in occupation. He admits. Yes, I was in occupation.
Of 200, he admits. Not
very well. 200, he
and that 200 has been given away by you.
Milord, very well. Milord, 200, he admits.
Yes.
Milord, he is aware of my position of occupation. Now, Milord, I say, come to the court and say, well, Milord, it's not 200. I was tenant of 400. Out of that, 200 has been given. Now, my lord, while obtaining the plan, my lord, he shows my remaining 200 in the plan. He shows my remaining 200 in the plan. And my lord obtains an extra FAR. My lord, when he makes construction without throwing me out, without dealing with my rest 200, what will happen? My lord, I approach the court and obtain an instruction claiming and tenancy over my 400. Court protects very well.
Against whom? Against whom?
The order is there, my lord, court protects. My lord, he files a suit suppressing this fact, or my lord, not bringing, when I bring this,
I am not a party. How can I suppress it?
that I bring this fact to the knowledge of the court, trial court refuses injunction on the ground, you are not entitled, my lord, they went up in appeal. My lord, I apprise the court, my lord, of this fact, this pendency of this suit, and my lord, injunction passed there.
So there is no suppression as such.
The suppression, my lord, with
Because they were not parties to the earlier suit. So there's no question of suppression.
no, they were served with the copy of the injunction, may not be party, they were sent.
Yeah, Baba.
Because
How it can be binding about? My lord, order 13 2A, my lord, to some extent, my lord.
Binding is something else, but having knowledge of the injunction is another thing.
Oh,
whether it's binding or not today.
It is his suit. It is his suit, or it should be my suit. I have to prove his tenancy.
He was having knowledge of the injunction, if I may so place it that way, not suppression, but he was having the knowledge. He doesn't disclose before the court that there is another injunction subsisting by a same coordinate basis.
Disclose any order of injunction wherein he was not a party. He is not supposed to disclose. I am sorry, I don't think I can grant an identity order at this stage.
No, not identity, my lord. What I am saying today is, my lord, we are, since, my lord, he says, my lord, his plan is there. My lord, showing my 200 square feet. Let that 200 be protected, not to change it, my lord, not to alienate.
It has been given over by you. This is the document.
So, with the remaining, my lord, let there, my lord, I check.
There is no story of
My lord, today,
you are not able to show any document to prove your prima facie case.
my lord,
You
today,
have to come up with a single yes. Where is your document? No prima facie case in your favor. All the documents say that 200 that has been given away by you. Then,
my lord,
what
then
remains?
may I submit one this way? My lord, when both the courts are aware, my lord, that there is a subsisting order of injunction, good, bad, indifferent, my lord, whatever. My lord, there is an order of injunction subsisting of the court. My lord, I pose this question to myself whether the other court will, my lord, taking note of this injunction, my lord, say that very well, I don't care.
That has not been said. The court has
The
dealt
court
with it.
overlooks this. Court doesn't even say so. My lord, court
Anticipate the order of the
my lord, court even says so. My lord, court even doesn't say so. You go and reject it. Get it rejected.
I am
It may
not
not
a
be
party, then
binding,
I have to.
but my position has been protected by some court of a coordinate with having a jurisdiction.
And that
So
is
what will happen to that?
Yes, my lord. May I give a small answer to my learned friend's argument?
Quarrel among each other.
Yes, I can give a small answer. I filed a suit describing him as the owner of this high court and get an order of injunction. Tomorrow, my lord, the authority will ask for the vacating of the same because I am claiming you to be the owner of this property. So why I am bound to go after him to vacate?
Not able to place any document before the trial court, the appellate court, or even this court. So serve notice on the others and come back before the regular bench. Has the construction started?
Yes.
So that's why, my lord, I said
He is not in possession. He took that money after accepting 37 lakhs.
for a moment.
No, that is why. After that,
Where is your 200? How do you identify your 200?
this is armed twisting litigation.
I can identify only by the photographs now.
Is that possible? Can the court pass an order of
Then what is in that suit? You can ask for the identification.
Not even stated the identity.
Identity is at the ground floor. Identity is at the ground floor. Milord, suppose in a building, in a ground floor, Milord, somebody in a shop. Milord, and my shop room is being
Parted and
acknowledged
bounded by?
Milord,
Parted and bounded by?
Milord, it has to be the property.
No, subject to question, my lord, the shop.
It should be your application.
He makes the entire what has been mentioned as the schedule. That's why I am indicating your lordship. The schedule which was mentioned in the earlier suit is indicating the parted and bounded by the entire property. But tactfully mentioned only 400 square feet without identifying where the 400 square feet is. We are admitting he was there 200 square feet. We have gave money. Let him produce because
and appear before the regular bench. I'm sorry, I don't think I can help you in this matter.
Milord, I would only
No
say, Milord,
document
Milord,
as such.
without jumping them as to construction, let them not alienate the remaining 200. That be protected.
As on this day, my learned friend is not in a position to substantiate his claim. Prima facie. Then my lord.
Construction overnight, that is, if his submission is.
Yes, I'm ready. I'm ready. Let him also deposit because the Supreme Court says the equitable remedy, injunction. He is enjoying that 37 lakhs for handover the 200 square feet. I am saying he's the owner, he's the occupier of the 200 square feet. He's saying in a 400 square feet he's there.
He's saying 200, he's not saying 400.
No, 400 out of which 200 given to me.
Yes, yes.
So if I succeed today, or he may succeed, he is seeking for an order of injunction restraining me from alienating or something else. Then also, if in long run, if he loses that, then I'll be the loser. I'm unable to enjoy my property. Let him show his bona fide by depositing that amount.
The judgment. Heard learned counsels for the parties. Heard learned counsels for the petitioner and respondent number 7.
সবাইকে represent করছো?
I am the power of attorney holder, my lord. 7.
Of all the respondents.
So there is no necessity for any further.
No, notice is not required. Yes, for the parties.
My lord, only one thing, my lord. Since 3 of them has died, my lord, which is admitted by them also. My lord, 3 with respect to the heirs of the 3, my lord, they have not taken any steps whether they will be added
It's
or
abated
not.
already. There is no question of substitution now. It has to come under order 9 now.
Yes, let that be recorded. Abatement against the rest of the plaintiff. Lord, his power is now at stake because the development agreement, if all the owners, my lord, who has given the power is no more alive, all of them, few of them are alive, his construction is liable to be stopped on that ground. But the heirs do not come up and.
My lord, who will be affected person? He is not in a position to espouse the cause of the others.
6 have died.
Yes, 1, 2, 6 have died. Lord, his construction is liable to be stopped here.
It is submitted on behalf of both the parties.
A tenant, after accepting money, is not challenging the title of
Admittedly,
construction. 37 লাখ টাকা জমা দেয়া আগে তারপরে injunction.
1, 2, and
ভালো মামলা করেছে
6. So you have included them as parties here also?
I cannot change the cost title unless that is changed. I cannot change because the department will obstruct in 5 steps. So that's why I seek leave to expunge them. And according to that extent, they have died, no steps taken. Will not therefore will not correct that position.
It is recorded in the impugned order itself.
Recorded. Wait a minute, I'll record this. They are respondent numbers in the mixed appeal?
Mixed appeal. They are the respondent numbers. 1, 6, and 2.
In the mixed appeal also it's 1, 2, and 6.
No, it's plaintiff number 1, Nandalal Shaha. Plaintiff number 6, Sonalal Shaha.
Admittedly, plaintiff numbers 1, 2, and 6 in the title suit.
The living brothers and sisters, my lord, the estate has been duly represented.
Being number
Estate of the reason is duly represented.
In 1242 of 2022.
Living brothers.
1242, the title suit number.
Yes, 1242.
Being title suit, being 1242 of 2022 has expired and have not been substituted by their legal heirs.
My lord, record my submission that the estate of the disease has been represented because other heirs will be represented by the other heirs also. Yes.
Lord, he wants to expunge these 3 names. I'll just allow him. That's it. A learned counsel for the petitioner seeks to expunge the names of. They are.
Lord, here opposite parties number. Lord, 1, 2, and 6.
The names of opposite party numbers 1, 2, and 6 from the cost title of the present application on this ground. Paragraph, the prayer is allowed. Stop, the cost title of the application be amended accordingly. Paragraph. The judgment of the learned additional district and sessions judge, fast track 4th court, Barashat, North 24 Parganas, passed on 5th August 2023 is assailed in the writ petition, in the application, in the present application. Stop. Paragraph. Though the petitioner claims to be a tenant in respect of 400 square feet of the plot in question, which is a shop room, and further claims to have delivered possession of 200 square feet therefrom in favor of the respondents in lieu of rupees 37 lakhs.
37 lakhs.
37 lakhs for the respondents to raise construction thereon, comma. The petitioner is not able to produce a scrap of paper before this court to substantiate his claim of being tenant in respect of 400 square feet. Stop. Paragraph per contra, comma, learned counsel for the respondents, learned counsel for the opposite parties submits that the petitioner was a tenant in respect of only 200 square feet and has made over possession of the same in favor of the respondents upon receipt of the amount of rupees 37 lakhs. Stop. Paragraph. In view of the above, comma, this court does not find any cogent ground for stay of the order impugned at this stage. Paragraph. Let the matter be placed before the regular bench.
Grateful, dear Lord. গলা বসে গেছিল তো প্র্যাকটিস করছি throat was choked
He
was back
Yes.
that's why today I'm practicing.
Oh, that's why he's practicing.
May I get back the copy of that free stick?
Yes, next matter.
Service.
Service.
Hmm? 647, my lord, I am appealing for the plenty opposite party. My lord, I am for the defendant petitioner. My lord, the petitioner has come before lordship challenging an order allowing an application under order 6 rule 7.
You are for the petition?
I'm for the petitioner, defendant petitioner, my lord. And the plenty opposite party, my lord. My lord, initially, my lord, the suit was filed for the declaration and permanent injunction against a football club, unregistered football club. Not making some XYZ as a representative of the football club, and thereafter, my lord, injunction was obtained. And thereafter, my lord, the plaintiff, my lord, filed an application under order 6 rule 17, changing entire thing, the nature of the suit, the schedule of the suit, the respondents, and the respondent whom he represented as a the defendant respondent representing the club, our club.
Contested matter.
Well, so far, when the extension is Yes, well,
Uh,
221, my lord, the extension, the suit was allowed to be proceeded with. Now, my lord, it was about to, my lord, disposed of. It is why we, on the last occasion,
31st August 2021.
and 22 September 2022, it was extended up till, and thereafter, my lord, it was about to, my lord, disposed of. My lord, we didn't pray for it. After puja vacation, it was fixed,
Have you
and
filed
then
the
it was
petition?
yes, my lord. Now, what we are facing, the lower court is, my lord, extending the date, but every day we are facing a cost. Either, my lord, hear out the suit or hear out the petition, or, my lord, extend it for a limited period. Otherwise, my lord, we are facing the cost on every occasion. It is not proceeding there. In September 2022, it was about 2 months completed, but somehow, my lord, it didn't appear, my lord. It was not proceeded thereafter, my lord, and we didn't also, my lord, prayed for anything more thereafter. I mean,
Application has been filed
yes,
for-
application filed.
For a limited period. The interim order,
Interim order.
limited period. Can 1 of 2022.
Can 2, my lord. Can 1 is disposed of.
1.
Can 2.
Can 2 is not in the file. Give me a minute, please. Oh, yes, can 2 is there. Can 2 of 2023. The petitioner seeks extension of the interim order
9 July 2020.
granted on 9th July 2021. Paragraph. Heard learned counsels for the parties. Paragraph. Since an interim order of stay of all further proceedings of the title suit being number 14 of 2019 pending before the learned civil judge within bracket junior division, comma, second court, comma, Krishnanagar, comma, district media. It's granted for the since was granted by an order passed on 16th September 2021 and extended thereafter, comma. The said order be further extended till 29th February. Some reading time.
As well.
29th February.
Man.
Or 2024 or until further orders, comma, whichever is earlier. Can 2 of 2023 is disposed of.
May to appear as, my lord,
Before the regular bench.
regular bench. Under the heading, my lord.
To be placed before the regular bench. Heading and all, the bench will decide. You know how it's conducted before. Next. So I do not know the procedure.
Only the concept, my lord knows contest application motion and like that.
Let the bench decide.
We want the matter to be disposed.
Yes.
We both of us want the matter to be, my lord, disposed of.
It's mentioned before the regular bench. Next. 48.
Lord, 648, I beg your pardon, we have the petitioner. If I am permitted to submit, other side quick.
Respondents, the opposite parties.
Yes, my lord, the affidavit of service has all been filed. The learned advocate has also been intimated that the matter will come up to Detective Dina Didi.
Mr. Partho Chakraborty.
Yes, my lord. This is the intimation was also given to him regarding the matter to be mentioned before your lordship. May I support?
What is your urgency?
My lord, the urgency is a particular company is practically on the brink of being finished due to this delay in respect of this particular matter, which is continuing for the last about 20 years or more. Now, what has happened is my clients are otherwise promoters, not that type of promoters who can deal with properties worth crores and crores. No, they are promoters who can deal with properties of a limited extent. Now, they agreed to take certain bricks from the opposite parties in respect of the construction which would be made. Now, there are in course of their continuation of business, they handed over certain money. In fact, the total money which is due from the, or rather due at the time of filing of the suit from the opposite parties were about 41 lakhs and odd. Now, in respect of that, no step was taken on behalf of the respondent to see to it that the amount is paid out. Thereafter, the amount the lordship can well imagine from 2004 or 2005 till today, the amount would be more than 1 crore. Now, the situation so far as my clients are concerned is absolutely pitiable. They are unable to do any work. Now, in such situation, when the written statement was filed on behalf of the opposite parties before the learned trial court, they admitted that yes, a sum of 16 lakhs was kept with us. Malat, kindly appreciate, I'm saying 41 lakhs. Then I'm also submitting a sum of 16 lakhs has been paid by them. And they say that we have given bricks worth 7 lakhs. Admitting in paragraph 11 of the written statement, we have put in the written statement on record, where they say that a sum of rupees 7,61,000 and odd is payable as on date, that is in 2003, 2004. That amount, if taken today, would be more than 25 lakhs. Yes. What has happened is very peculiar. I should say this, it hits us also. The learned lawyer who was dealing with the matter, he just lopsided everything. And there was an application for under Order 12, Rule 6 of the Court of Civil Procedure, indicating that there should be judgment upon admission in respect of part of the amount. Your Lordship knows in respect of the provisions of Order 12, Rule 6, it is also stated there, you can claim a part of the amount and give a go-by to the other party.
What's the order impugned in the present application?
I'm just coming. The Order 12, Rule 6 application was rejected. In spite of there being categorical admission on the part of the opposite parties, in written statement, the learned court below found the order is not order cannot be passed. We came up with a revisional application. The revisional application, while it was pending, there was a stay granted. While at kindly appreciate, there was a stay granted. While the matter was pending before this court, the trial court dismissed the suit for default. It took 8 years to get the suit restored. 8 to 10 years. After the restoration, we have come up with this application saying that this application under Order 12, Rule 6, which was to be heard by this court, has not been at all heard. Let it be heard. Let there be an order by the court to say that this amount is otherwise payable by the opposite parties or not. This part only, we stick to this part only. Let it be paid to us. This is all what we want in respect to this matter. If your Lordship kindly appreciates that this would be a very interesting situation to otherwise go through so far as the petitioners are concerned.
Is undoubtedly, but then I think a further notice has to be served upon.
We have already given them a notice.
They have appeared before.
They have appeared before the court.
This was supposed to appear on January 10th, the notice.
Today, my lord, today is January 10th, the matter was mentioned before your Lordship.
That was for mentioning.
It was for mentioning, my lord.
And এখানে ওরা appear করেছে.
And my lord, your Lordship will kindly come to order dated 17th of May 2020.
I think the matter can wait till the
My lord,
regular bench comes.
Situation is very, very peculiar, or else I wouldn't have
Because the regular bench will join.
I know that. I know that. But the difficulty is
I
that
would have directed the matter if the other side was there, but the
other
intentionally
if the intentionally avoid, what can we do? What can we do? Your Lordship kindly says.
We have given notice for mentioning on.
They intend appearance sometime in 17th of May 2023. Your Lordship kindly sees the order. They are very much on record.
Where is the order impugned? The judgment impugned?
202.
At page 202.
Operative courtটা এইটা করে দাও জজের সাবমিশনটা 2005 205
My lord kindly comes to page 202.
And operative part যেটা জজ করেছে that is at 205.
This is my lord order dated 30th of September 2005.
Yes.
And my lord, I urge before the Lordship to kindly come to page 205.
So I have to.
My lord has got 205, my lord. The handwritten order, I'm sorry, can't be helped. Certified copy
yes.
which has been obtained. Yes.
Yes.
I have carefully perused the plain written statement and the instant petition and the WO and also the documents wherefrom I find that the admission is not clear and unequivocal. The defendant have admitted that the plaintiff have time to time paid rupees 16 lakhs to the defendant, but the amount has been adjusted by 7,47,055. And now 7,61,671 is outstanding. My lord, we are asking for this money now.
This is the observation.
This is the observation of the court, my lord. If that be so, then we are asking for only for this money with interest. Interest may be taken by the court as the court decides. Though it is 4% per annum, 4% per month, I am not on that. Lordship fixes up a rate of interest. That is categorical observation by the court below. That too we will not get and wait for years and years and years together. My lord, kindly appreciate from 2005, we are now in 2024. Nearly 20 years have gone.
When have you come up against this order? This is an order of 2005.
Yes, my lord, as I submitted, my lord, earlier we came up. Then, in spite of a stay, the matter was dismissed for default by the trial court. Then we had to come up again.
After the suit was restored.
After the suit was restored.
What about the earlier revisional application? That's still pending.
We had to withdraw.
You have to withdraw.
Because the matter was
Because of the dismissal.
dismissal, we had to withdraw. We couldn't keep it pending. Everything is stated, my lord, in the application. Everything.
যে সুটের এখানে বলছে এইটা জাজমেন্টটা ওরা দেখিয়েছে 204 that is also in our favor. তুমি দেখাও
আপনি this matter.
The application was opposed by them.
Yes, opposed by them. My lord, kindly comes with written statement. Let me show your lordship the written statement which they have filed.
Written statement starts from page 65.
My lord, kindly comes to page 65.
And 69 paragraph 13 হচ্ছে ওদের state হবে paid.
See, I think we need to file the serve a further notice and appear before the regular bench.
My lord, I respectfully submit. I appreciate your lordship's problem which is coming up. But in spite of notice, if they do not come up, then what we can do?
Because I also feel that you are entitled to interest. I cannot.
Yes, interest. We are entitled to interest.
Of the other side.
Yes, man.
Their presence is very much required because it is a very good case on your side.
My lord, kindly disposes of the matter, or else I wouldn't have come to otherwise dispose.
That will be a futile exercise in presence of. If the other side would have been present, I would have done.
Will not come.
My lord, we'll fix it up tomorrow, my lord.
No.
We'll give a notice to them to come down. We'll give a notice to them. Let them come down.
Tomorrow, in a day, it will not be possible. Come back on Monday.
Monday.
Monday 3:30 will come.
Yes, come
Monday 3:30.
30 তে specially fix করে দিন।
Because it can actually be disposed of.
My lord, I'm grateful.
I require the presence of the other side.
My lord, 22nd, your lordship will be taking up matters.
Yes, till 22nd.
And then, my lord, kindly fix it up on 22nd. We'll come back. We'll give it a fresh notice.
12টার সময় fix করে দিতে হবে।
But without notice, it will be difficult.
My lord, we'll give a notice. We'll serve a
Without
notice.
presence of the other side. I mean,
Yes, my lord. Your lordship will kindly record a small order so that we can give them that notice.
আর এটা time fix করে দিন।
And fix up a time, my lord, as your lordship. 3:30. As your lordship, please. As your lordship.
Let the time be
3:30.
Yes.
Let this be item number 1.
3:30 te hobe.
None appears on behalf of the opposite parties despite service of notice. Paragraph. The petitioner is directed to serve a further notice. Petitioners are directed to serve further notice upon the opposite parties intimating the adjourned date. Stop. It is made clear, paragraph, it is made clear that the matter may be taken up for consideration on the adjourned date, even in absence of the opposite parties.
Grateful, man. Grateful.
Paragraph, let the matter appear under the same heading on Monday, 22nd.
At 3:30 p.m., my lord.
3:30 matters are taken.
I know,
from
but
3:30.
prior to 3:30, this matter has been taken up. That's why. Grateful, man.
Please keep a watch because it will be taken up immediately after completion of Group 7 matters.
Grateful, man.
Next.
My lord, I am for the respondent. My senior is coming, so I am praying for not today.
Your lordship, I am also praying for not today.
Petitioner.
Yes.
Regular bench.
Grateful.
Both the parties pray for accommodation. Let the matter be placed before the regular bench. The matter be placed before the regular bench. Late হবে না। 6:50. No one. None appears for the parties. The matter be placed before the regular bench.
Well, 50 on I am opposite party number 1.
Petitioner.
Please. In this matter, আপনি বললেন আমি শুধু in this matter I am appearing for the board of works. I am praying on the accommodation, my lord, because I left my brief in my chamber.
Who is appearing for the petitioner?
Lord, I am the opposite party number one.
Yes, I'm looking for the petitioner. Yes, anyone for the petitioner?
No.
Next one. None appears for the petitioner. The matter be placed before the regular bench.
I'm deeply pleased.
Deeply obliged.
I am for the petitioner, my lord. My lord, it's a very unfortunate incident. Loan taken by one of my colleague, loan disbursed, but the dealer did not supply the car. Now bank is deducting and
There was a direction for service. Have you served?
lordship, yes, I have served lordship. But lordship, today I might come back with a different prayer before your lordship. Lordship, my initial prayer that bank should not deduct any money from my account. And suit injunction was not granted as if there was an application of SUVRA Act. Lordship, I am not going into anything. My ad interim is only rejected. So lordship, if your lordship, then I preferred a misappeal and misappeal has not been allowed. So I am before your lordship. My only prayer before your lordship, my suit, including the interlocutory application, may be disposed of by the court as expeditiously as possible. Why? Because car has not been delivered to me. It is lying there. For everyday delay, the car is depreciating. So lordship, if the lower court takes that view,
Please show me the service. I'll pass an order.
service to them. My lord, may I file the affidavit within the course of day? And this is the service, lordship. I mean, service, I will do it right now, lordship.
Where is the service? Where is the track report? This is not service. The track report?
Track report?
This is only the postal receipt.
Lordship, may I take it back? May I take it back?
Because there's a specific direction of.
I know, lordship. But since I am not placing the application on merit anymore, if your lordship kindly dispose of that.
The innocuous prayer of the petitioner is for a direction upon the learned trial court for expeditious disposal of the title suit being number 600.
Lordship.
600. Suit number 600.
600 of 2022. You're asking for expeditious disposal of this suit only. That's
Lordship.
all.
Lordship. Along with the interlocutory application pending there.
The suit is disposed of. That will be
Lordship.
automatically done.
Lordship.
Paragraph. Since an order passed in this regard shall not affect the respondents prejudicially, comma, the application respondents opposite parties the application is disposed of, directing the learned trial court. Who is the trial court?
Baripur Civil Judge, Junior Division, Second Court.
Trial court being the learned civil judge.
Junior Division, Second.
Bracket Junior Division, comma, Second Court, comma, Baruipur, comma, South 24 Parganas, to dispose of the title suit being TS such and such pending before him as expeditiously as the business of the court would permit. Urgent certified proceeding.
I'm much obliged. Much obliged.
Next. বললাম তো application application. Next.
But I am for the petitioner. Plaintiff is the petitioner suit for eviction. But I am for the defendant. Application for amendment has been rejected. Well, challenging that order, this revision application is filed. Well, since today time is short, urgency is, my lord, day after tomorrow is the date fixed for the trial court. And since November, my lord, the trial court has granted time. It is the last chance, my lord, therefore, it
Till
will.
November, that what time has been granted?
My lord, I prayed before the revision application is pending here. I am praying their time, my lord, since the revision is pending. But this time is, my lord, last chance. Therefore, day after tomorrow, my lord, the matter will be taken up. And what I am praying, my lord, since my Mr. Giri is appearing, my lord, let there be limited stay so that we can move the matter before the regular. By the impugned order, my lord, the application for amendment, whereby I have stated that initially the suit was filed in respect of 5C by 1B. That is the premises number. I have got the property, my lord, two property. One from Dhananjay, it was initially 5C by 1A. I have purchased that property. After purchase, it has been renumbered as 5C 1A by 1. And I have got the another property from my father, which is 5C by 1B. Subsequently, two properties have been amalgamated as, my lord, 5C 1B. My lord, after purchase from Dhananjay, it was renumbered as 5C by 1A by 1. My lord, that statement was not in the plaint. In the plaint, my lord, specifically it was mentioned that the plot number 5C by 1B. That explanation has been given by the
That statement is not, my lord, pleaded in the amendment petition.
And
At present, my lord,
You are aware of this fact all throughout, even before institution of the suit?
I have stated in the plaint. I am not stated. I have stated the new number.
5C by 1A and 1 is a different premises in connection with 5C by 1A, not 5C by 1B.
My lord, I have stated everything.
No. At present, your lordship can give me stay, but his suit. I had filed affidavit in opposition to the effect because the new fact has been pleaded here.
So let the suit be stayed for some time because
Yes,
it's
yes.
fixed for peremptory hearing.
My suit, my lord, but I have to.
I will file affidavit in opposition because the wrong statement and also the new facts.
The petitioner, being the plaintiff in title suit number 18 of 2014, pending before the learned civil judge within bracket junior division bracket closed, second court, Alipur, has challenged the order passed by the learned trial court on 22nd August 2022, turning down the petition filed by the plaintiff petitioner under Order 6, Rule 17, plaintiff petitioner, under Order 6, Rule 17 of the Code of Civil Procedure. Paragraph. According to learned counsel for the plaintiff, for the petitioner, premises number 5C/1 capital A, Dr. S.N. Ghosh Sharoni, SARANI, was amalgamated with premises number 5C by 1B and renumbered as 5/C/1 capital A/1.
No. Well, it is, I purchased the 5C 1A. It was mutated in my name and renumbered as 5C 1A by 1.
This is the submission. This is the submission.
Yes.
Not plead.
Submission.
Yes.
And the other property we have got from my father, that is 5C by 1B, my lord, that is amalgamated with that property, and new number is, my lord, the 5C 1B.
No.
Oh, new number is 5C 1B.
Yes. Suit has been filed in respect of 5C 1B. Only this explanation is required to be. Original tenanted premises is 5C by 1A. I have purchased. It was renumbered as 5C by 1A by 1.
I understand. Yes, I got it. Was renumbered as 5C by 1 capital A by 1 and thereafter amalgamated with premises number 5C by 1B, the new premises number being 5C by 1D.
Agree.
The petitioner sought to incorporate this fact in the plaint by way of an amendment, which was rejected by the learned trial court. Paragraph learned counsel for the petitioner submits that the matter is scheduled for peremptory hearing before the learned trial court on
19th of this month, 19th January.
19th January.
But defense argument has already been completed.
Peremptory hearing, defense.
No, defense argument has already been completed. Kindly see the input note. Yes. Argument stays.
Scheduled for hearing argument on 19th January 2024.
সেটা আলাদা কথা।
Paragraph. It appears from the submission made on behalf of the parties that the petitioner has made out an arguable case, and the matter is required to be heard on merits. Paragraph. In the meantime, comma.
Well, I am denied the same, my lord. You will also kindly record it. The fact which you have submitted. That is, yes, but in record it, my lord.
No, the matter. Heard on merits, তারপর একটা line করুন, learned counsel for the opposite parties denies and disputes the contention of the petitioner and seeks to use an affidavit in opposition in this matter.
Yes, my lord.
Paragraph.
And not pleaded in the amendment petition, the submission. Yes, yes.
Paragraph in all further proceedings, in the meantime, take it again. All further proceedings of title suit number 18 of 2014 be stayed till 29th February. 2014 matter.
My suit, and not on a.
Let it be stayed.
Original tenant has died 5 years now. Now it is not eviction of trespassers. That is another aspect. That will do. That is decided by a trial.
Let it be stayed till 31st January, not February.
31st is next week. 2 days are holidays. 23rd and 26th.
No, mention before the court and get it heard. It's a very old.
Second week of February.
15th February. Till 15th February 2024. Paragraph, the matter be placed before the.
In the meantime, I will file affidavit in opposition. বলে দিচ্ছি না। ঠিক আছে। কতবার করব? তুমি বলো।
Next.
I am appearing for the petitioner. My lord, your petitioner is the plaintiff in the title suit for decades. But caveat is there. We had also given notice to them.
Not fine.
Shilona? He was just there. Just now, my lord, I was waiting. I saw him there. Must have gone. I'll indicate to your lordship, my lord.
What is your urgency?
My lord, urgency is that, my lord, there's a development agreement. 36% owner share, 64% developer share. Thereafter, my lord, when the building was started, thereafter a further development agreement as to allocation of the flats was to be entered into. The draft supplementary development agreement exchanged, same 36% owner share recorded. That was forwarded by them. When the final supplementary development, I am one of the owners. When the final supplementary development agreement comes, that has been interpolated and changed to 30%. So becomes 70% and 30%.
For the opposite party, Malor, in this
Maintainability.
Malor, we have taken
Maintainability of the.
Maintainability point, Malor. For the trial court, section 8 is pending, Malor. And my lord, my landed senior friend, my lord, counterpart is also appearing in this matter, my lord. They are contesting the section 8, whether that is because it's a commercial suit that has to be filed with an arbitration clause. And second thing is that is all these are pending before the learned trial court. And this application, my lord, Lordship will kindly see.
Receive copy of the application.
Yes, my lord, we have already filed.
21.
And this is a 2022 order, my lord. There is no urgency as such.
I am not concluded.
No, sir.
I just make my submission. In this circumstance, my lord, when the supplementary development agreement has been made in contravention of the original development agreement, we filed the suit for declaration and injunction. Ad interim order was refused. Misappeal preferred, misappeal admitted with injunction. With injunction, but then misappeal, when it came to be disposed of, that injunction was vacated. Now, the only issue is, while admitting the misappeal is only from the ex parte ad interim, refusal to grant ex parte ad interim order.
Yes.
So, on the strength of the materials where ex parte order was declined, the appellate court granted the injunction. What the course would have been, send it back for final hearing. Because in the misappeal, there is hardly any scope for entertaining a written objections. Because the order has to be tested on the strength of the plaint and the petition. So instead of that, the trial court in the hearing the misappeal vacated the injunction. But the question is, today you cannot take into account other materials for vacating the order. There was
Injunction was initially granted, is it?
by the appellate court.
By the appellate
By the appellate court. But I'll show your lordship the order. Kindly take the order by the appellate court, 18th of November 2021. This is at page 360. 361.
The certified copy is there.
Yes, yes. This is not the impugned order. This is the order by which the misappeal was admitted. That is what I am showing, my lord.
At page?
Page 360. This is the first order by the in the misappeal.
Yes.
Kindly see 361. Last paragraph of that page. Considering the submission of learned lawyer for the appellant, perusal of the materials available in the case record, it found that appellant plaintiff has become owner of the suit property and documents mentioned. So it is found that plaintiff has shown prima facie case to go to trial, as there is chance of transfer of the suit property at any moment. Balance of convenience going to be irreparable loss in favor of the appellant, urgency of the matter, and to avoid multiplicity of the proceeding, I am of the view that 36% of the residential property is required to be preserved, not also in respect of the entire. It is only the owner's allocation which has been preserved, 36%. And he is the developer. Now, kindly see, after this new deed has come, the ratio is changed from 70, he becomes 70, I become 30. So he still admits that 30% is mine. It is only a dispute regarding 6%. So that is why my prayer, the 6% he need not sell now. He can sell his 70%. He can encumber 70%. Even 30% he cannot do because he admits 30% is mine. So what is his urgency that he will immediately sell that 6%? But therefore, the balance of convenience demands.
Order impugned.
Yes, my lord. Order impugned. Your lordship will kindly see. That is at the last. I'll show you.
8th October 2021 order.
Yes. 3rd August 2022.
29th August.
29th August.
29th August 2020.
Oh, final hearing on 3rd August 2022 বলে miscellaneous এটাই তো দেখাচ্ছে।
এখানে
points for determination. Yes, my lord, 29th of August. I'm sorry. This is yes. It is quite a longish order.
3rd August.
29th
But
August.
20 lot will
29th
kindly
of
take
Signed 3rd August. Yes.
ডেটটা ভুল হচ্ছে।
29th August.
29th August.
Kindly see, it is they have filed an application for vacating. So it is not tested. Kindly, your lordship will come to internal page 4 of that order. Towards the bottom of that page, last paragraph at internal page 4.
Yes. Yes.
Accordingly, respondent submitted a petition praying for vacating order dated 18 November 2021, stating inter alia that suppressing facts. They have not implemented necessary power of attorney. So, my lord, a vacating application is being considered by the appellate court on the strength of new materials. The proper course, in my most respectful submission, is the trial court order is to be tested on plaint and petition. Then, your lordship, on the basis of this, kindly see page 5, 3rd paragraph. Upon perusal of plaint injunction application in the suit, as well as section 151 of CPC submitted in the appeal, So therefore, the new facts are being gone into. So therefore, it is not that the learned trial court's order is being judged. Then, my lord, the learned judge has found that there are certain facts emerging which are noted here. But nowhere is the consideration regarding this fact that what is the dispute? 6%. I am actually praying for protection of 6%. Nowhere, my lord, kindly see. But the learned judge frames certain questions on the basis of materials disclosed in the 151. And finally, page 7 is the actual finding, my lord.
Yes.
The facts asserted. Now, kindly see, after those points, my lord, at page 7, juxtaposition of the facts enumerated above with the question emerging from several questions of fact, law, as well as mixed questions of fact and law. It is all obvious that answers to such questions cannot be availed of without going through full-scale trials. So, not here, my lord, I raise this objection, my lord. It is not a matter which is being appeal, which is being heard out after a final order of injunction. That is very important, my lord. These are the considerations which can weigh in the mind of the injunction court at the time when an injunction application is being finally disposed of. Kindly see page 8 top. On the other hand, status of respondent quo the suit property has not been denied. I am not denying. That being the position, order of injunction passed on 18th November might cause undue hardship to the respondent. Very well, that can be modified. But I am never asked for injunction against his share also. Apprehended chance of transfer of the suit property cannot be construed as tilting the balance of convenience irreparable loss in favor of the appellant, inasmuch as his locus standi in maintaining the suit is not above suspicion. Accordingly, prayer for vacating the order dated 18 November merits to be allowed. This is why the order has been vacated on a vacating application without giving the opportunity to the trial court to decide that. I could have understood the appellate court coming to this conclusion on the basis saying that on the materials disclosed before the trial court in the plaint, no case for injunction is made out. Then, well, that is an absolute exercise of discretion at the ad interim stage by the appellate court. But where the appellate court has already granted a status quo, at the final hearing and vacating application is entertained, and therefore it is, kindly appreciate, it is not the first order which is being tested. It is 18th November order passed by the appellate court which is being tested by a coordinate bench, if I may say so, like that. So, my humble submission is this, that if the injunction is restricted
to the 36%.
Yes, he will not deal with the 36%. Let him do with his 76%. I am the 64%. I am not bothered about that.
My lord, first of all, my lord, challenging that appeal court's order, my lord, we have come before this honorable court, my lord. The honorable court, my lord, we have taken 3 points. That this suit was filed by one Manish Kumar Rai. He is no one to the property. He is, my lord, the son of the partner. Well, I'll come back. My learned
partners have individual shares allotted.
I
have not gone into that.
My learned, yes, that is the preliminary point. My lord.
Very well, your lordship, kindly see the development agreement. I will leave it to my learned friend. Kindly just see, my lord. Kindly come to this page, my lord.
Where is the power of attorney?
Owner's allocation, my lord, it is mentioned page 280. Kindly come to page 280.
Josh have ordered a record. Power of attorney dying.
Power of attorney also not something.
280, yes.
280, kindly see, my lord, owner's allocation. 7. Owners will be entitled to get 36% of total constructed area as per sanction plan. Together with the aforesaid 36% will be distributed between partners of Measures KMP and company as follows. So all the 3 partners will get 12%. My father is Kiran Kumar Rai. So I have come through Kiran Kumar Rai. Because the shares are already delineated. That is why it is not necessary that the entire partnership firm has to file the suit.
Subsequent suit file for
The second suit has been filed, my lord. My lord, what has happened, my lord?
These
My lord,
will have to
my
be
lord, my
determined
learned
by the
senior friend,
international
my lord,
court.
should not disturb me. My lord, we have taken a point of, my lord, lordship will kindly take order 3, rule 1 and 2, my lord. We have specifically stated that Kiran Kumar Rai, my lord, Manish Kumar Rai, who has filed the suit, my lord, he is nobody to this KMP company. My lord, KMP company, my lord, is a proprietorship firm in whose name the property has been registered, and the developers has entered an agreement with the KMP company.
The document talks about partners, by proprietorship firm.
Lordship will kindly seize, my lord.
Page 280.
My lord, 271, my lord. Lordship will kindly takes 271.
Yes.
My lord, Messrs. KMP and Company, a partnership firm incorporated under the provisions of Indian Partnership Act 9.
Partnership firm?
Yes. My lord, I just, my lord,
That's proprietorship. That's why I thought it was.
yes, this is a partnership. My lord, what has happened, my lord? Incorporated under the provisions of Indian Partnership Act 1932, my lord, registered office here and there. Vidya Sharma, Brijesh Kumar Rai, Shailesh Kumar Rai, Kiran Kumar Rai are the owner, my lord, son of late faith by occupation here have been called and referred to as the owner, my lord, shall in respect to the, my lord, first part, and Ganga developers, my lord, being the developer. Now the suit has been filed, my lord, this plaint has been filed by one Manish Kumar Rai. My lord, we have taken the point that all the owners were not made parties, my lord, and Manish Kumar Rai was not having any authorization from his father, whatever maybe, to file this suit. My lord, suit has been named in the name of Manish Kumar Rai. Well, it is not a case that Kiran Kumar Roy has filed a suit through constituted attorney. Lordship will kindly seize the plaint, my lord. Plaint available. Yes. My lord, page 70, my lord. This is the appeal, my lord, and after that, my lord, plaint.
The power of attorney has not been filed?
No, and it has been specific recording.
Granted power of attorney.
Yes.
The father.
Yes.
Where is that power of attorney?
My lord, Lordship will kindly take the impugned order, my lord. My lord, at the time of scrutiny, my lord, internal page 2 of the, my lord, misappeal order number, Lordship will kindly takes me.
Please give me a minute. Let me find out the power of attorney. His eligibility.
Yes. My lord, Lordship will kindly takes, my lord, internal page 4. Respondent challenge. This is the fourth paragraph. Respondent challenge such order of before Honorable High Court, Calcutta, which directed this court to dispose of the appeal finally, considering points relating to defects in party, any prayer for vacating, and interim order of injunction. This order they have not annexed in the writ petition. This is in revisional application. Accordingly, respondent submitted a petition inter alia praying for vacating order dated 18 November 2021, stating inter alia that the appellant has instituted the suit suppressing facts. They have not implemented the necessary and proper parties who are the partners of the partnership firm. The relevant power of attorney has not been brought into the record by the appellant. The respondent stands to lose more, having invested sufficient amount of money in the project. The supplementary development agreement dated 3rd March 2020 has not been challenged by the partnership firm or its members. The partnership firm is not a registered under Indian partnership firm, and there is a specific bar against filing suit out of contract. Appellant retorted inter alia stating that respondent is violating the order of ad interim temporary injunction and has submitted the prayer for vacating such fulfillment. Now, my lordship will kindly comes, my lord. Upon perusal, 3rd paragraph. Upon perusal of the plaint and the injunction, application filed in the suit as well as the petition under section 151 of CPC submitted in this appeal, I find that certain facts are emerging forth thereof which can be enumerated in the manner as follows. Father of the appellant is a partner of a partnership firm which owns the suit property. The appellant has claimed that he is the constituted attorney of his father, though he has not submitted the document whereby the power of attorney was conferred upon him before the learned trial judge. Rather, copy of such document was submitted before this court on 6th August 2022. Well, after that, such power of attorney has been issued by one Kiran Kumar Rai in favor of appellant, appointing him as lawful attorney to act in the name and on his behalf in respect of the suit property. None of the partners, including father of the appellants, have been implicated in the suit. Nature of partnership firm has not been established producing the partnership deed, or for that the matter producing any document to establish that the firm has been duly registered.
grounds taken by the vacating application.
Mala, we have come before this honorable court, Mala, challenging the order of the Miss Appeal before the appeal court where injunction was granted for a limited period. We have taken all these points. This honorable court, Mala, laid down all these points that you take these all points before as a vacating application before the appeal court. But on the basis of the order of the High Court, this application was hard out. What my learned senior friend has submitted, that Mala, he has done it in its own, it is not a case. It has been only done as per the remand of the honorable court. Mala, it was an open remand by the honorable court that you decide on these all points. After
That is strike at the merit. You have to be on merits, isn't it?
Mala, Lordship will kindly sees, Mala, in this suit, Mala, we have taken that Manish Rai is nobody. Mala, today Kiran Kumar Rai, he has come, Mala, before this court. Mala, already filed a second suit and that is pending. And in that suit also, they have could not have obtained any order of injunction.
On what grounds?
Same. Well, only copy paste. I can show before Lordship, if you grants me an adjournment, I'll come back tomorrow. But I can show you it is a replica of this entire suit. Entire thing has been done. After this order of injunction was vacated by the trial court, they filed this application before the High Court. They have never moved this. Only urgency, I don't know what they had been splitted, my lord. It has come before your Lordship, my lord, and they have moved for the first time before the High Court after, my lord, 2022 order. This order was passed in August 2022. After that, 1.5 years, they have come before this honorable court. But this is the latter suit, I have a copy, my lord. Lordship will kindly seize, my lord. This is filed by, my lord, his father, which is pending, and it is also the same self of cause of action, my lord. It has been rejected. Injunction order has been rejected. The harassment I am suffering after investment of 5 crores of rupees, that they have also gone before the illegal construction. And Justice Gangopadhyay has dismissed their petition. This is unheard of. Yes.
Criminal case dismissed.
Yes. This is before the Justice Gangopadhyay, they have taken that this is illegal construction to stall my entire work, construction work. It has been dismissed. They could not make out a cause before that. And this is, my lord, this is recent. After that, they have come before this honorable court by taking this point. And criminal cases have been also filed against me. This is also dismissed. 5 to 7 litigations I am facing.
Matter requires extensive hearing, regular bench. No order.
Lordship will place it before the
Heard learned counsels for the affidavit service. Heard learned counsels for the parties. Because it cannot be disposed of in a day.
I was only saying that I am not going to restrict their 64%.
But
Only
the points that they raise are also should be they are.
Oh, but not my lord, not at this stage of the ex parte stage, my lord. This is to be decided on written objection after the trial court applies its mind. But now kindly only say this, my lord, regarding this 6%, they will not do anything.
Not at this stage. Let the regular court decide.
They will already, my lord.
The matter has to be heard extensively before passing any order.
It's a registered deed, my lord.
Affidavit of service, heard learned counsels for the parties. Paragraph. The matter needs extensive hearing. Paragraph. The matter be placed before the regular bench. He needs extensive hearing for the matter. Yes, next matter. Judgment গুলো ফেরত দিয়ে দেবেন। Judgment গুলো ফেরত।
I am opposing this application.
Petitioner before your lordship is a defendant in a suit for eviction on the ground internally on default. But what happened, my lord? Petitioner entered appearance with application under section 7(1) and 7(2). My lord, 7(1), my lord, he went on depositing the rent, my lord, current rent, my lord. My lord, 7(2), my lord, disposed of, my lord, without taking into consideration of the rent control deposit. Against that order, petitioner moved before this honorable court. This honorable court directed, after setting aside the order, to hear out afresh the 7(2) application. But that after remanding of that order matter before this court below, trial court, my lord, again, my lord, without considering the rent control deposit, my lord, passed out the order. Thereafter, my lord, I filed an application for modification. This is the order under challenge, that is the under on the prayer for modification of that order. My lord, court is saying this court has no power to modify its own order, and in the order itself, there is no explanation to what extent why those rent control challans deposited in favor of the plaintiff opposite parties landlord was not accepted, why it to be regarded as bad deposit. My lord,
Is it recorded as bad deposit?
yes, without any explanation. But kindly have a look to the impugn order. In the meantime, they preferred on say application under 7.3,
My lord, first taking the this is soon, just you can finish it. From taking this petition on whose behalf this order is to be sought for me. Who is here? Petitioner. Petitioner dead. Petitioner no more. How my little friend is seeking the order against the dead on behalf of the dead person?
But kindly have a look, my lord.
No.
Rajesh Kumar Dhawan has died?
Yes, my lord. This kindly see the order of the trial court. How in my calendar can move this application?
My lord, petitioner, my lord, it has been filed, my lord, through his brother, who is the power of attorney holder, Rajesh Kumar Dhawan. What you have handed it over?
Who is the defendant in the suit?
Sole defendant has gone.
Rajesh Kumar Dhawan.
Is the sole defendant?
Yes, yes.
He has expired. This is the order of the court.
When?
Please find out.
I don't know, my lord. When?
Please find out. It is your client.
Yes, yes. The order was passed against the dead man.
No, this today I are asking the order against the dead man.
Defendant files Hajir. Defendant is yourself, isn't it?
Yes, yes.
Defendant files Hajira along with death report of sole defendant.
But it is not known to me.
দেখানো।
আমাকে তো আগে বলতে হয়।
Then it is your duty to seek the instruction from the client.
Oh, it is 23, my lord. I have, my lord, preferred it is November 23. And my lord, my lord, filed this application, my lord.
August 22.
Yes, 22, my lord. During the pendency of this.
Please take necessary steps.
Have to take steps here.
Yes. It is submitted on behalf
पहले
of
बोलना चाहिए।
आपको बोलेगा नहीं आपका एडवोकेट आपका एडवोकेट नहीं
and
बोलेगा
the petitioner has expired. Paragraph, learned counsel for the petitioner seeks to take necessary steps in this regard. Paragraph, the matter be placed before the regular bench.
Next matter also same.
Same person.
It is the same, my lord.
Actually, there is a one tenancy comprised of 2 rooms. My lord, the transferring landlord filed 2 eviction suit. Though, my lord, there is only single rent receipt issue.
656, same order.
Same.
My lord, I am for the petition.
Yes.
But there are 2 petitions. One is 15 and 15.9. Against the malad, against the same party, but the different 2 orders. First order, my lord, page 28.
Page
28, 28.
Yes.
Fact of the case is why left me with my younger son. Then I have filed an application under section 9. Opposite wife came at my house and says he wants not to restore the rights, conjugal rights. Then I withdraw the petition and filed the divorce petition. Against the divorce petition, they have filed an application section 23.
They have filed an application under
Why?
24.
24.
Yes.
Alimony penalty granted 5,500. I am paying on them. I am having my widow, aged mother, and my big son. His education cost is there. Total hospitality of my mother is there. My son education cost is bearing to me. I have taken the house building loan that in huge amounts deducted per month. Also, I have already made the LIC to my sons and wife. They also deducted huge money from me. He said, I am getting 30,000 to 35,000 as my salary. But the deduction is more than 15,000. 5,500 malad directed, I used to pay.
Yes.
Thereafter, I came to learn that my wife is having the relationship with one gentleman. Then I have stopped. Now, what is happening? In the meantime, she has filed an application for enhancement of the alimony penalty line without disclosing any reason. It was enhanced from 5,500 to 11,000. This order passed on July 15, 2022. It is an expiry order.
July 15. Yes.
Then Lordship will kindly come to the next order. Page, the certified copy. Second page. Second page. Order number 81, dated November 3, 2022.
Order number 81, yes.
81. Landed court below, without disclosing the reason, directed the relative authority to attach 2,03,500 from my salary, as well as I have to pay 11,000 per month. There is no at all discussion, and there is also no breakup. How 2,03,500 is made.
Please serve the other side. Let this be stayed for the limited
Yes,
period.
get from
No caveat record for them. Heard learned counsel for the petitioner. Paragraph, the order passed by the learned additional district judge, first court, Paschim Medinipur on 3rd November 2022 in mat suit number 70 of 2015, directing the divisional railway manager, Southeastern Railway, Kharagpur, to deposit an amount of rupees 2,03,500 in the bank account of the opposite party wife by way of attachment of salary of the petitioner is under challenge in the present application. Paragraph, learned counsel for the petitioner submits that the said amount has been directed to be attached without assigning any reason therefore.
Grateful, madam.
Paragraph, the petitioner is directed to serve notice upon the opposite parties, serve copy of the application, along with the annexure thereto upon the opposite parties, and file affidavit of service on the agenda date. Paragraph, the order impugned dated 3rd November 2022 be stayed
Order number
till 29th February 2024. Paragraph, the matter be placed before the 24, or under further orders, which are reserved.
And my lord, also another order is there. Lordship kindly consider that order number 79, that is enhanced 11,000.
Enhancement that is not required to be stayed at the moment. The attachment be stayed.
That is item number 59.
Matter, yes,
Now, two matters, my lord, 567 and 569.
I have called till 657. Come back tomorrow. The matter be placed before the review.
659.
Before you may I, my lord, under compelling circumstances, item number 683, my lord.
Come back.
Lord,